Almighty God, we give thanks to you, the creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this house here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations. Amen, amen. Namaste.
Oath or affirmation, announcements by the Speaker.
Honourable members, I have received communication from the Honourable Kamla Prasad Bisessa, SC, MP, Member for Superior, and Ms. Anita Haynes, MP, Member for Tabaquite, who have requested leave of absence from today's sitting of the House. The leave which the members seek is granted.
Bills brought from the Senate, petitions, papers.
The Minister of Finance.
Madam Speaker, I have the honor to lay the following papers. The audited financial statements of East Port of Spain Development Company Limited for the financial years ended September 30th, 2014, 2015, 2016, and 2017. We refer to the Public Accounts Enterprises Committee.
Honourable members, the question is that papers 1 to 4 be referred to the Public Accounts Enterprises Committee. All in favour say aye. Any against? The ayes have it. Leader of the House.
Thank you very kindly, Madam Speaker. Madam Speaker, I have the honour to lay the following papers. Paper number 5, the ministerial response of the Ministry of Tourism, Culture and the Arts to the 9th report of the Public Administration and Appropriations Committee on the examination of the implementation of the 2021 budget with emphasis on the green economy. Paper number 6, the ministerial response of the Ministry of Health to the 10th report of the Public Administration and Appropriations Committee on the examination into the findings of the report of the committee appointed to investigate the factors contributing to clinical outcomes of COVID-19 patients in Trinidad and Tobago. Thank you very kindly, Madam Speaker.
Leader of the House, I believe there's paper number 7.
It's an additional paper. Paper number 7. Thank you. Which is the dossier of documents surrounding the appointment of a Chief Administrator, Tobago House of Assembly. Thank you very kindly, Madam Speaker.
Reports from committees, Prime Minister's questions, urgent questions.
Member for Urupuch East.
Thank you. Thank you very much, Madam Speaker. To the Minister of Works and Transport, in light of the devastating damage and inconvenience caused by the heavy rainfall yesterday and this morning, will the Minister state what urgent clearing, cleaning, and drainage works will be undertaken from today to assist residents and prevent another incident of destruction and human suffering?
Minister of Works and Transport.
Thank you, Madam Speaker. Madam Speaker, I do have a written answer, but I will not use that. And there's a simple reason for that. Based on the question that was posed to me about the devastating flooding and destruction to human suffering, I don't know where that came from. Yesterday, we got some flash flooding, and within 1 hour, the water receded. Yes, some debris came down, and as of half an hour ago, I was in most of the areas where that happened, and it is already cleaned. So I don't know where the human suffering and so. I just want to remind the member, we are in the rainy season, and in the rainy season, we must expect rain. What happened yesterday was a large volume of water that was anticipated based on the local and international weather pattern. What that resulted in was some severe flash flooding in certain parts of the island. The reports that I have, no rivers broke their banks. There was some overtopping in the Diego Martin area, which is normal with that volume of water. So in terms of the human suffering and so, I sympathize with the areas, the low-lying areas in Trinidad where we do get flooding from time to time, but the ministry will continue on its program of desilting and improving the infrastructure in Trinidad so that we can cater for the new norm brought upon us by climate change, high sea level rise, and the abnormal amount of rainfall that we're getting at this time. Thank you.
Member for Orupuchi.
Thank you, Mr. Minister. In light of the front page of the Express today, which states midday storm rip-off roofs cause traffic nightmare, flood blows, could I invite you, and would you agree, to read the proper answers supplied to you by the technical people of your ministry and don't extempo? Could you do that?
Member, that's a statement, and there's a lot of conjecture in that, so I'm not going to allow that question. It's out of order. You have another question? Member for Orupuchi.
Just for clarity, ma'am, I'm allowed 2 more questions since you disqualified that.
Well, is that a question or is it a statement? Well, you decided to use a question that you know is improper, so you have a question left.
No, well, I have 2 questions.
No. You have 1 question left. Please, use it wisely.
Okay, I understand fully. Minister, in light of the fact that the ministry received $167 million recently in the midterm review, could you indicate what projects are ongoing and would prevent flooding, further incidents of flooding during this time? What thing? And Minister, do you think it's time that you stop loading?
Member for Orupuchi East, I know how passionate you are, and I know how much this issue means to many people in Trinidad and Tobago, but that doesn't give us the right to offend the standing orders, which a senior member like you is so well seasoned in your knowledge. So could you decide which question it will be? And I would also say, before you decide which question, that the first question, according to the standing orders, is out of order.
Minister, in light of the $167 million recently approved for your ministry, specifically for dealing with drainage and flooding and so on, would you indicate which projects are ongoing in those areas flooded yesterday and this morning that could alleviate and prevent further devastation in the event of rainfall?
Minister.
Thank you, Madam Speaker. Madam Speaker, just to clarify, rainfall and flooding and cleaning drains have nothing to do with roofs blowing out. That has to do with wind. We have no control on the wind. Madam Speaker, the ministry has a very aggressive drainage program ongoing, where we are desilting water courses, we're rebuilding banks, we're upgrading pumps, we're upgrading gates, and there are several different aspects, and that money will be spent there. However, I need to indicate to the member, flooding has to do with the volume of rainfall and the capacity of the channels. So as a government, we will do our part, but we have no control on the new norm, the new weather pattern that is affecting the entire globe. Just this morning, I don't know if the members look at the international news, it is happening around the world. And we will not be spared. We will not be spared, but we need to work. All hands must be on deck, and we must not use flood as a part of the politics in Trinidad and Tobago. Thank you.
Member for Chaguanas East.
Thank you very much, Madam Speaker. To the Minister of Social Development and Family Services, will the Minister advise this House what immediate emergency mechanisms are being instituted or contemplated to assist those residents affected by the widespread flooding across the nation yesterday and today?
Minister of Social Development and Family Services.
Madam Speaker, thank you very kindly. On behalf of the Minister of Social Development and Family Services, in the same vein as my colleague, the Minister of Works and Transport, indicated, there was almost immediate runoff as it related to quite a number of areas, and consequently, up to now, we have not received any reports of persons who are in need of any assistance from the Ministry of Social Development and Family Services. However, if we do receive those reports, the Ministry of Social Development and Family Services is already in a position to determine the extent of the recovery that is needed, and the ministry will respond accordingly. Madam Speaker, I think it is a good opportunity to indicate that the Ministry of Social Development and Family Services is consistent in the responses that it gives once any need is identified and assessed. The ministry gives for emergency food support $510. For household items as per the guide, up to a maximum of $10,000. For a refrigerator, $4,000. A stove, $2,500. A bed with a mattress, $1,000. Living room sets, $3,500. Mattresses alone, $1,000. Dining room sets, $3,500. Chests of drawers, $2,000. Washing machines, not dryers, $2,500. A wardrobe, $3,000. Kitchen cupboards, $2,000. Madam Speaker, for minor house repairs, the Ministry of Social Development and Family Services gives up to $20,000 in funding for material only. For sanitary plumbing assistance, up to $15,000 for material only. The clothing grant is up to $1,000 per
Honourable
person.
Member, your speaking time is now expired. Member for Shagonasis.
Thank you, Madam Speaker. Madam Speaker, based on the Minister's response, Minister, can you indicate whether the Ministry of Social Development and Family Services have liaised with the regional corporations to receive information so staffing can be deployed accordingly as it relates to reports?
Member.
Madam Speaker, as the member well knows, there is a process. The Ministry of Social Development and Family Services is already in contact with all the DMUs who may be affected in the various corporations, and to date, we have had no requests because, as my colleague said, the runoff was swift. Where there has been roof damage, we have provided tarpaulins, and we have also provided cleaning supplies in several instances. Other than that, we have no reports of need in terms of the emergency supplies that we give here.
Member for Shagonasis.
Thank you, Madam Speaker. Madam Speaker, based on the Minister's response of tarpaulins being provided, this is actually a report of persons requiring assistance to roof repairs, and you are saying no reports. Minister, you are saying no reports. Are you in a position to state whether or not you do not have the information or you intend to get the accurate information during the course of today or over the course of the weekend so that you can give the public the proper information?
Minister.
Madam Speaker, in the areas where there are proper representatives, like Port of Spain, Laventille East Mover, and the other aspects of and Laventille West, along the East-West corridor, including all the Diego Martins, where there were incidents, the members of Parliament and the former councillors have all been in the field, and they gave out what was necessary. If there is further information which has not come to hand, then the Ministry of Social Development will get involved. Madam Speaker, we are not in the habit of encouraging flood politics, and consequently, we have already done our part in terms of providing tarpaulin if it was necessary, We have also contacted the Self-Help Commission and done our part, and the corporations have been activated.
Questions on notice. Requests for leave to move the adjournment of the House on definite matters of urgent public importance. Statements by ministers.
Honourable members, I understand that there is agreement that the Honourable Prime Minister will speak until the end of his statement. Yes? Prime Minister.
Madam Speaker, I thank you for the opportunity to make the following statement. I am authorized by the Cabinet to make this statement of clarification on a matter of public administration. As you are aware, Madam Speaker, there are two aspects of administration of Tobago. There is the Tobago House of Assembly, commonly called the THA, which has its autonomy under the Act with all its rights and responsibilities, and there are the residual responsibilities of the central government administered under the Central Administrative Services Tobago, CAST. Both of these arms of administration have as their head a chief administrator, THA, and permanent secretary at CAST, respectively. These are both public servants under the Act and jurisdiction of the Independent Public Service Commission. Madam Speaker, it also goes without saying that for peace, good order, and progress to prevail in Tobago, and also in Trinidad and Tobago, it is absolutely essential for there to be respect for each other and a good working relationship between all officers and agencies of state charged with these responsibilities. It is in recognition of this imperative that I, as Prime Minister, have always gone out of my way to harbor and foster a good working relationship with my colleagues and associates in Tobago and between the central government and the Tobago House of Assembly. Notwithstanding the anticipated cut and thrust of the politics, some recent developments in Tobago has not only raised eyebrows, but have produced disintegration and discord, followed by serious allegations and some measure of anxiety and distress in some quarters. Throughout these periods of evolution, the central government has been careful to keep a respectful distance whilst ensuring that everything is done to maintain the designated services to the people of Tobago. However, Madam Speaker, this did not prevent the authorities there at the first opportunity to seek to embroil the central government and especially the Prime Minister in whatever difficulties they were experiencing at the moment. It is in this environment, Madam Speaker, that in an address to the Assembly last Thursday, 22nd of June, that the Chief Secretary, in a fit of hopefully genuine misunderstanding, made some very serious allegations against the Prime Minister and the government of Trinidad and Tobago. It is the view of the Cabinet that such accusations and misinterpretations, if left unattended in the public mind and domain, could grossly mislead the citizenry, not only in Tobago, but across the nation, with grave consequences leading to the deterioration of the relationship between the people of Tobago and the rest of the nation. Madam Speaker, it is common knowledge that until a designated officer is identified by the Public Service Commission for appointment to the post of Chief Administrator, substantive or acting, there is no role for the Prime Minister in the public services where matters of ranking and selection are concerned. A proper interpretation of the law would show that in pursuance of an appointment to be made, the Prime Minister's role only comes into being when the Public Service Commission identifies a designated officer and seeks to confirm from the Prime Minister whether he has an objection to the selection put forward by the Public Service Commission. This is the first time that the Prime Minister is to be involved in the process, to be followed immediately as per the law by consultation between the Chief Secretary and the Prime Minister. It is clear, Madam Speaker, from the behavior of the Chief Secretary, ascribing his own skewed interpretation to the consultative process, that the Chief Secretary does not have a proper understanding of the phrase designated officer, the meaning of the phrase subject to, and the words selection and appointment. In thoroughly disregarding or misinterpreting these words and phrases, the Chief Secretary has been driven to operate in the realm of conspiracy theories which seek to implicate the Prime Minister in a fleet of wrongdoing or suspicion for which the record will show there is absolutely no basis once a clear understanding of the law is invoked. The following allegations have been made and put unchallenged in the Tobago House of Assembly's record by the Chief Secretary. He alleged that in February 2022, the Prime Minister appointed Ms. Ethelyn John as acting Chief Secretary without consulting the Chief Secretary in violation of the THA Act. At the onset, it must be established that the Prime Minister has no power to appoint that officer. Such is the sole responsibility of the Independent Public Service Commission, who in doing so is required by law to alert and inform the Prime Minister for certain conditions to be met. He quoted liberally from his letter of March 10th, 2022 to the Prime Minister, but was deliberately silent on the existence of a letter to him from the Prime Minister of March 3rd, 2022, where the consultative process was initiated. The last line of that letter states that, and I quote, Madam Speaker, from the letter, in accordance with the provision of subsection 4 of section 71 of the Tobago House of Assembly Act, Chapter 2503, I wish to consult with you on the above-mentioned appointment. That's the letter from the Prime Minister to the Chief Secretary, which played no part in his carryings on. My letter of March 3rd, 2022, to the Chief Secretary to initiate the consultative process was an immediate response following the notification on March 2nd, 2022, from the Public Service Commission of their selection of a designated officer. Madam Speaker, this should make it quite clear that as Prime Minister, there was no action or intention on my part to do anything other than responding according to law in the most expeditious manner. I responded on the same day that I was notified. One could easily be led to conclude that the Chief Secretary omitted to mention the existence of this particular piece of correspondence from the Prime Minister to him because it was inconvenient to the case he wanted to make about satanic behavior on the part of the Prime Minister and disrespect to his office and the THA in general. Madam Speaker, I seek your protection from the member for Orapuch West. I would like to speak in silence, please. East, sorry.
Okay, so I ask all members to observe Standing Order 53. The Prime Minister will be heard in silence. Prime Minister.
Thank you, Madam Speaker. The fact that the designated officer at the time attempted to assume duty before the actual appointment was finalized was unknown to me. That office had participated in an unauthorized handover before an actual appointment was made, and to which the Chief Secretary quite properly objected. This was rectified by the Permanent Secretary in the Office of the Prime Minister by withdrawing the unauthorized officer once that development was made known to him as head of the public service. The situation was remedied by the acceptance of the Chief Secretary after conversation with the Prime Minister and the issuance of the requisite appointment letter by the Public Service Commission. So contrary to what the Chief Secretary is now saying, no willful disregard was initiated or supported by the Prime Minister or the Office of the Prime Minister. The raising of this matter now in his season of despair and the attaching of sinister ulterior motives, such as introduced by the Chief Secretary in the Assembly on June 22, 2023, is more than unfortunate. Madam Speaker, it is disturbing. With respect to the accusation that a second instance of no consultation, disregard, and disrespect on the part of the Prime Minister was imminent, along with the development of the absence of a Chief Administrator, the Chief Secretary continues to misrepresent the role of the Prime Minister, even as he was properly advised by the Director of Public Administration, the Office of the DPA, that the Commission, I'm quoting here, Madam Speaker, from the DPA's letter, the Commission had previously appointed an officer to act as Chief Administrator from May 17, 2023, unquote. And I quote again, subject to the consultation as provided for in the Constitution, unquote. And Madam Speaker, I want to repeat that. The DPA advising the Chief Secretary that the process is that the person, the Chief Administrator, is being appointed to act by the Commission subject to the consultation as provided in the Constitution. The Chief Secretary continues to believe that no officer should be designated by the public service without prior consultation with the Chief Secretary. In fact, Madam Speaker, it is the Public Service Commission's action of identifying and designating the appropriate officer for consideration for an appointment that triggers that consultative process between the Prime Minister and the Chief Secretary. In his haste to make damaging allegations against all comers, particularly the Prime Minister, the Chief Secretary is blinded to his own shortcomings, which results in misleading of the population of Tobago and, by extension, Trinidad and Tobago. The acting Chief Administrator, Ms. Ethelyn John, retired on May 17, 2023, creating a vacancy in the Tobago House of Assembly to be filled by a designated officer to be appointed by the Public Service Commission only after the process is triggered by the head of the Public Service and the Commission. The remainder correspondence of this issue was circulated between the outgoing chief administrator and the head of the public service. This triggered communication between the head of the public service and the Public Service Commission. It also attracted the attention of the chief secretary, who wrote in anticipation of selection and consultation taking place. However, once again, the chief secretary, in his intervention, disregards the fact that a designated officer is not an appointed officer until an appointment is made, and the Prime Minister is not brought into the process until such designated officer is identified by the Public Service Commission. Madam Speaker, additionally, it is the identification of the designated officer that requires the Commission, in moving towards an appointment as required by law, to seek a no objection from the Prime Minister. On receiving this notification from the Commission, the Prime Minister is required to consult with the Chief Secretary before advising the Commission of the status of the designated officer. A no objection would see the Commission's recommendation moving to an appointment being made. The corollary is that if, only for good lawful reason, the Prime Minister offers an objection, the Commission must cease the process and advance another officer for consideration. Correspondence from the Public Service Commission dated May 16, 2023, and received by the Office of the Prime Minister the next day on May 17, 2023, indicated that Mr. Richie Toppin, the permanent secretary at the Office of the Prime Minister, CAST, has been designated as the officer to act as the chief administrator at the THA. This letter would have ordinarily triggered a consultation process between the Prime Minister and the Chief Secretary before the appointment was formalized. Madam Speaker, however, this letter was never advanced to me as Prime Minister because the permanent secretary received a letter of the same date, May 17th, from the outgoing Chief Administrator, THA, informing him, as head of the Public Service, that a number of allegations of misconduct have been made against the designated officer, Mr. Toppin. The Public Service Commission, being so advised, immediately withdrew its letter of May 16th, which advanced Mr. Toppin for consideration to the position of acting Chief Administrator at the Tobago House of Assembly. It is interesting to note, Madam Speaker, that I was not aware of the letters passing between public officers when I met with the Chief Secretary in Tobago. A letter dated May 15 from the Chief Secretary on the matter of the appointment and consultation process was received at my office on May 16th. We also communicated cordially by phone and subsequently met on May 22nd in Tobago. It is at this juncture that I should point out that quite separate and apart from any of these proceedings requiring my involvement, I sought in my normal duties on that said occasion to meet with the Chief Secretary to discuss a development plan for Tobago, which was to involve the THA with the support of the central government. During this meeting, the Chief Secretary raised the matter of his preference for the officer that was mentioned in his letter of May 15th. Not knowing about the public service issues surrounding the withdrawal of the Public Service Commission's letter, I gave an undertaking to support the officer as advanced by the Chief Secretary. That was the settled outcome. What I did not know then is that there was an interdiction of the permanent secretary at CAS arising out of the proceeds of an audit which was undertaken and spoken about quite frequently and passionately by the Chief Secretary himself. I also subsequently found out that a series of correspondence between the head of the public service, chief administrator, and the permanent secretary and CAS on this subject of the audit was taking place from as early as November 2022. The letters of November 16th, November 28th, and December 1st. These being routine public service matters, the Prime Minister was no way involved and therefore could not influence the decisions in any person's favor, public officer or contractor, as recklessly stated by the Chief Secretary. The outcome of these exchanges resulted in the suspension of the designated officer and the creation of the absence of a chief administrator because the Commission had to redo its selection process but was delayed in advancing this action due to being incorrect, a situation which was only rectified by June 12th. I want to make it abundantly clear, Madam Speaker, that contrary to statements, insults, accusations, and insinuations made by the Chief Secretary, that neither I nor my office have expressed any interest whatsoever in obtaining his audit report for pleasure or for nefarious purposes as he described, namely, and I quote, to assist friends of the Prime Minister, unquote, who the Chief Secretary accuses of criminal conduct. Madam Speaker, at no time during any of our discussions, face-to-face or otherwise, did I ever discuss or request any information from or copy of the audit to which the Chief Secretary frequently speaks. To the best of my knowledge, Madam Speaker, no person in any of my offices or any officer reporting to me has ever sought to obtain information from the Chief Secretary about his forensic audit. Therefore, Madam Speaker, for the Chief Secretary to wantonly put on the record of the Tobago House of Assembly that he will not give a copy or provide any information about the audit to the Prime Minister because he is satisfied that such information is to be used by the Prime Minister to assist persons whom the Chief Secretary wishes to see face criminal charges and put behind bars is scandalous in the extreme. The Chief Secretary stating that he is satisfied that the Prime Minister wishes to have this audit to provide technical escape loopholes for his friends is a slander most grave. The issue of the Tobago House of Assembly being without a chief administrator for over a month is entirely an outcome that had as its origin the Commission's designated officer having to be withdrawn because that officer's name in the May 16 correspondence of the Commission was concurrently named by the THA in its correspondence on May 17th, advising the Commission that Mr. Toppin was the subject of allegations of misconduct and was being put on charges as effective in the letter of the Chief Administrator. Madam Speaker, in dealing with whether the Chief Secretary knew or was party to the actions of the Chief Administrator as it relates to the disqualification of Mr. Toppin, Chief Secretary Augustine makes it quite clear that such matters lie entirely in the hands of the public servants within the realms of the public service. However, he is not prepared to accept that the public service matters of selecting a designated officer to become Chief Administrator is a matter that lies within the public service and for which the Prime Minister may have little knowledge and certainly no involvement until a no objection is required. For the Chief Secretary to conflate these public service actions with his pet conspiracy theories in his battles against contractors and allow himself to put on the record in the Tobago House of Assembly that the Prime Minister has some sinister interest in the selection and promotion of Permanent Secretary Toppin, who he accuses of wrongdoing on behalf of contractors, is yet another instance of the Chief Secretary using the Assembly chamber to spread propaganda and slander against persons who have no recourse in that chamber. Madam Speaker, it is to be noted that the people of Tobago were first brought into the picture of these developments when the Deputy Chief Secretary, I presume with the sanction of the Chief Secretary, who was missing at the time, addressed the media and made it quite clear that the absence of a Chief Administrator was as a result of the Office of the Prime Minister not doing its job and was deliberately interfering with and undermining the Tobago House of Assembly. Nothing is further from the truth. The fact is that the first time the Prime Minister had anything to respond to was when a letter dated June 21st, 2023 was issued to make an appointment to fill the vacancy created by the retirement of Ms. John on May 17th. It is to be remembered that the May 16th correspondence was the first attempt by the Commission to have a designated officer identified to fill the vacant post of Chief Administrator by May 17, 2023. This effort failed because of the intervention of the Assembly by way of the outgoing acting Chief Administrator reporting to the public service on the content of the audit. Incidentally, as stated before, this was done on May 17th, the last working day of the now retired acting Chief Administrator. In my capacity as Prime Minister, I received on June 22nd, 2023, from the Public Service Commission, correspondence dated June 21st, advancing an officer to fill the vacancy of Chief Administrator. It should be noted that this is the first letter that I received from the Public Service Commission advising the vacancy and its intention to fill it. This is the one that was withdrawn, Madam Speaker. Well, not withdrawn. Having had prior agreement with the Chief Secretary on the said officer now designated, I replied on June 23rd, clearing the way for the Commission to finally appoint an acting Chief Administrator for the Tobago House of Assembly. This appointment is being made in accordance with the provisions of subsection 3 of section 121 of the Constitution of the Republic of Trinidad and Tobago. Madam Speaker, it is to be noted that contrary to the Chief Secretary's fulminations and confused state of mind, there is no requirement for any consultation with the Chief Secretary before a designated officer is made known and available to the Prime Minister. It is only when the Prime Minister receives correspondence identifying a designated officer that the law requires that the Prime Minister consults with the Chief Secretary prior to the appointment of the officer. Madam Speaker, as a person of such vast experience and so familiar with the workings of the public service, you and many of my colleagues in this honorable House would know it is not uncommon, because of the exigencies of the situation, for officers to be made to assume responsibilities in acting appointments long before the authorizing paperwork is completed. In 2015, Madam Speaker, as a new Prime Minister, I was required to sign off on mountains of files at the Prime Minister's office so that public officers in a variety of ranks and situations could be duly authorized and be appropriately paid for the assumptions and work done as far back as 2013 and 2014. This was completed without any fuss or fanfare. However, in Tobago, one has to be particularly careful, since these exigencies may provide tinder for unnecessary conflagration if such opportunities and developments are deemed to be useful from time to time. The real danger is, Madam Speaker, that on every occasion that this happens, it diminishes us all a little bit more and presents a clear and present danger for discord to prosper. Madam Speaker, as for me and my government, we will follow the law. And Madam Speaker, we will put the interests of the people of Tobago and the people of Trinidad first. Finally, Madam Speaker, so seriously do I take the slander and insinuations and allegations of the irresponsible Chief Secretary that as I make this statement of clarification and rebuttal, I laid in this House today as a paper a comprehensive dossier of all the relevant correspondence in support of what I have just said here today. Madam Speaker, I go further. If it can be truthfully shown by any of the authorities that I have mentioned or impacted here today that I have misled this House, I will immediately resign forthwith and hand over the reins to another in the interest of peace, good order, and progress of the people whom I have continued to serve to the best of my ability. Madam Speaker, I thank you and I thank all my colleagues. Madam Speaker.
I'm sure people are familiar with the standing orders, and people also know they're entitled to one question. So if members will wait for the Prime Minister to finish in silence and then follow the standing orders. Prime Minister.
Madam Speaker, I thank you, and I thank all my colleagues in this House for your patience and attention.
Member for Orange, please.
Thank you very much, Madam Speaker. Madam Speaker, notwithstanding the optimistic end, could I ask the Prime Minister, in light of the charges and counter-charges being laid in Scarborough and Port of Spain, where office holders are describing each other, one as satanic and one as a confused slanderer, does the Prime Minister believe in the national interest it is better for both parties to meet around a table with proper advice and sort out this matter rather than using the Parliament to attack each other in such a manner? Would the Prime Minister agree a meeting of the parties with proper advice is in the national interest rather than this weekly bouts of attacking each other in such a derogatory manner?
Madam Speaker, I've attacked no one. I've corrected the record, and I've put it on the Hansard for all times.
Personal explanations, introduction of bills, motions relating to the business or sittings of the House and moved by a minister, public business, government business, bills, second reading.
Honourable members, the debate on the second reading of the following bill, which was in progress when the House adjourned on Monday, June 5th, 2023, will be resumed. And a bill entitled An Act to Amend the Administration of Justice, Indictable Proceedings Act 2011, Act number 20 of 2021. Attorney General. Attorney General, you have 10 more minutes of full speaking time available to you.
Thank you very much, Madam Speaker. Madam Speaker, when I addressed this Honourable House on the 5th of June, I had just concluded my review of the bill which is before this House and the sections of the bill dealing with initial hearings. I move now to clauses 20 through to 37 of the bill, which deals with sufficiency hearings under the fast-track trial law. Madam Speaker, clause 20 of that bill does a number of things, but in particular, it removes, among others, references in subsection 6.2, subsection 1, where the Director of Public Prosecutions would now be subject to a sufficiency hearing. As mentioned earlier in my presentation, this bill proposes that the accused will be subject to a sufficiency hearing, even in circumstances where the Director of Public Prosecutions files a voluntary bill of indictment. The rationale, Madam Speaker, is balanced to ensure that while the Section 90 powers of the DPP are upheld, sufficiency of evidence is still to be assessed. Among other things, Madam Speaker, that part of the bill that we speak of, Clause 21, would insert after Section 19 a new section, 19A, which will deal with witnesses and witness statements as it pertains to a sufficiency hearing. It now proposes that the attendance of a witness shall not be required at a sufficiency hearing unless, on application, the master makes an order for the attendance of a witness who filed an unsworn statement. This, Madam Speaker, is a pivotal change to the way pretrial proceedings are conducted, remembering throughout my earlier presentation and this presentation that we are about expediting the process of the pretrial phase of trials of accused persons. The addition of oral evidence by way of further evidence and cross-examination has been identified as a major cause for the protraction of preliminary inquiries, which this bill seeks to abolish. Clause 23 of the bill will amend Section 21 of the Act, Madam Speaker, in subsection 2 by deleting certain paragraphs, C and D, and substituting new paragraphs to ensure that there is clarity in procedure as it relates to the admissibility of prosecution witness statements. Among other things, Clause 23 will also delete paragraph DA in Section 21.4 and substitute a new paragraph DA in order to clarify the procedure as it relates to a statement made by a person who does not speak fluent English. Additionally, this clause would amend Section 21.5 by repealing it and amend Section 21.8 by repealing and substituting a new Section 21.8 which pertains to a transcript of proceedings and evidence obtained under a treaty to be admissible as evidence at a sufficiency hearing. Madam Speaker, Clause 24 of the bill will amend Section 23 of the Act by deleting paragraph B, substituting a new paragraph B to clarify the procedure and provide for the Criminal Procedure Act relating to orders under Section 25 concerning a master's final decision at a sufficiency hearing. Clause 25 of the bill will amend Section 24 of the Act by inserting in subsection 1 the words "on the indictment," which concerns discharge of the accused. The clause also repeals sections 4 to 11 of Section 24 of the Act and substitutes it with the new subsections 4 to 6. In order to allow the Director of Public Prosecutions to appeal the decision of a master if the former is of opinion that the accused ought not to have been discharged. It also allows for the appeal of a master decision to the Court of Appeal in accordance with Section 65C of the Supreme Court of Judicature Act. Then clauses 26, 27, and 28 through to 30 make for further substantive amendments, Madam Speaker, of the Act. Clause 31 of the bill will amend Section 27 of the...
Just 1 minute. Please leave the chamber and get your device under control. Thank you. Attorney General.
Thank you, Madam Speaker. Clause 31 of the Act will amend Section 27 of the Act by repealing Section 27. This effectively removes Schedule 6 matters which were exempted from this charge. This is better aligned as the indictment is now being filed at the beginning of the sufficiency hearing process, so there is no longer a need to have a schedule which exempts matters from discharge due to delayed filing of the indictment. Clause 32 of the bill will amend Section 28 of the Act by deleting paragraph C of Section 28, inserting a new subsection 1A to account for where master is referred an accused to a judge for sentencing following an early guilty plea, and the Director of Public Prosecution is to be given notice of that referral. There are other substantial amendments that are proposed, Madam Speaker, to expedite the fast-track trial process in the currency of the sufficiency hearing. Clause 36 of the bill will amend Section 29(2)(b) of the Act by allowing the oath of a credible witness whose attendance is not reasonably practicable as a result of being outside of Trinidad and Tobago to be secured physically or by electronic means. The clause will also amend Section 29 of the Act by repealing Section 29(7). Then there is, importantly, Madam Speaker, Clause 39 of the bill, which will amend the Act by inserting after Section 32A a new Section 32B to deal with anonymization of documents for a variety of reasons. For example, the protection of witnesses. Importantly here, the original version of the document is always retained for court and internal purposes. Madam Speaker, Clause 40 of the bill will amend the Act by amending Section 33(2) by deleting the words, "Neither the prosecutor nor the accused elects to have the case determined in accordance with this Act," and substituting the words, "No order is made under Section 32A," in order to allow for savings under the Indictable Offences Preliminary Inquiry Act. Clauses 41 through to 44, Madam Speaker, address the ability of the Chief Justice to produce practice directions to make amendments to the schedules. And finally, Clause 45 of the bill, Madam Speaker, deals with consequential amendments as a result of the Act, namely the Summary Courts Act, Chapter 420, the Criminal Procedure Act, Chapter 1202, the Criminal Procedure Change of Venue Rules, the Police Service Act, and the Family and Children Division Act. Madam Speaker, what is very important to appreciate about this bill, which is before this House, is that it complements a host of reforms which have been undertaken over the past 8 years and work in tandem with those to reduce the delays associated with the pretrial process in criminal matters. We can note some measures: backlog identification at all levels of the court and prosecutorial division.
Attorney General, you have 2 minutes left.
Thank you, Madam Speaker. The creation of divisions of court and a number of other significant amendments that have been passed by this government, including the creation of a public defender system and generally the implementation of a fully computerized case management structure. May I indicate, Madam Speaker, as I close, that I will be moving an amendment to Section 5 of the bill, which is the Act, which is before this House, to ensure that due process will be ensured in relation to search and seizure, so that by that amendment, all persons whose premises are searched and seized will be subject to the oath which the magistrate, the master, will be required to take from the witness. And may I say finally, Madam Speaker, that the object of this bill, even without requiring, is legitimate. It is legitimate in its aim, it is proportionate, and is indeed necessary. And I look forward to hearing my learned colleagues' contributions on this very important piece of legislation designed to enhance our criminal justice system to provide for a speedy and expeditious trial process. With respect, Madam Speaker, I beg to move.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled "An Act to Amend the Administration of Justice, Indictable Proceedings Act 2011, Act Number 20 of 2011, be now read a second time. Member for Chaguanas West.
Thank you, Madam Speaker, for the opportunity to speak in this particular debate. Madam Speaker, as I start, I want to say that conceptually and as a matter of principle, that we on this side, we have no difficulty with abolishing preliminary inquiries. We do appreciate the backlog, we do appreciate the delay in the administration of justice, and so as a matter of principle, the concept of abolishing PIs is something that we would agree with. But moving away from that overarching position, I want to say that when we get down into the amendments that are being proposed by way of this bill, what we are seeing, Madam Speaker, and I say it respectfully, but what we are seeing really is what I would describe as a rag bag. It is a rag bag of proposed amendments leading to uncertainty and confusion. What we are seeing, I know the Honorable Attorney General spoke about clarity of procedure, but we run the risk, if we enforce these amendments, that we will end up with a rag bag of legislative provisions which promote, as I said, confusion and uncertainty, both of which are contrary to the robust running of the administration of justice and the justice system. But why do I say something like that, Madam Speaker? Madam Speaker, if I was to start with just a definition which was identified by the Honorable Attorney General when he was piloting the bill, and I go back to the first session of this bill, which was on the 5th of June, 2023, and we look at the Hansard. And Madam Speaker, with your permission, I will quote what the Attorney General had said. And this is what he said in relation to Clause 4. Clause 4 of the bill, Madam Speaker, importantly inserts definitions, among other definitions, and one or two of them are worth discussing. The term appropriate adult is introduced because appropriate adult, when you read it in relation to the different legislation that this fast-track law has to be read with, involves children and persons who fall within the brackets of age groups who will be referred to as appropriate adults who are charged with certain crimes, but we want to bring those trials to the earliest possible conclusion. What is, and close quote, that is the part of the Hansard that I am referring to. What is wrong with that, Madam Speaker, is that it shows from the outset that fundamentally, even when you deal with definitions of very important provisions, that the Attorney General is missing the mark. He is treating with appropriate adult as though that refers to children and certain vulnerable adults as having committed crimes, and that is not what the role of the appropriate adult is. Now, I start with that, and I want to show that as one, if I may say, one example as to why I started off by saying we are dealing with a rag bag that could lead to uncertainty and confusion. Madam Speaker, when we look at the appropriate adult definition, and this is something that came up, Madam Speaker, the House may recall, when we were debating the Evidence Amendment Bill, I believe it was February 2022, that it is a matter which I actually spoke about in terms of the appropriate adult. This definition that is being proposed in this act is equivalent, or I should say largely similar, to what was put forward in the Evidence Amendment Bill, which is also to be replicated in the Children's Act, an amendment which was brought by way of the Miscellaneous Provisions, Supreme Court of Judicature and Children, 2018. And so what the definition does is that, and I want to repeat it here because it is very important. I repeat that, Madam Speaker, being a Commonwealth country and adopting a lot of our laws from England, we follow something that is called PACE. And that PACE, for those who are not lawyers, that is really a significant advancement in the law, in criminal law, in the UK. And what happened with that from 1984 is that you would have seen that PACE was a piece of legislation that was meant to carefully balance police powers against the rights of the person engaged in the criminal justice system, so such as witnesses, suspects, and accused persons. So what you have in that balancing act, Madam Speaker, is that following PACE, they introduced something called the appropriate adult, and this I'm referring to now the UK, the United Kingdom. The appropriate adult is practically an institution, Madam Speaker, in its own right. They have appropriate adult schemes. They have a national appropriate adult network. You have guidance given as to what an appropriate adult ought to do. Till this day, Madam Speaker, and saying appropriate adult, this would be the third debate that I'm aware of, where we are speaking about an appropriate adult. Whilst you have who is an appropriate adult, you do not have any duties defined under the different pieces of legislation. So what I would say, Madam Speaker, is that when we talk about even the incorporation in this bill of appropriate adult, what we see in contrast to what has been put forward in the UK is that we are straying very far and far away from stating the duties, roles, and functions of the appropriate adult. And this, again, Madam Speaker, whilst I have spoken about it in detail in the evidence amendment bill, and which became law in February 2022, I will repeat, it betrays a lack of foresight. Just merely stating who is an appropriate adult, Madam Speaker, but going no further as to what such a person ought to do is something that it can create uncertainty. Uncertainty in an important bill like this will cause confusion. So I say that it must be precisely defined. Now, the reason for having these things properly defined, Madam Speaker, is that if we are talking about the interests of the administration of justice, certainty is something that we must have. And when I go to the actual provision itself, appropriate adult, as being suggested here, has the meaning assigned in Section 3 of the Children's Act. Now, Madam Speaker, what we see is that appropriate adult would include social worker, a welfare worker, and a JP. And what I would say at the outset is that this provision, without proper definition, it goes contrary to the judge's rules. What we experience now, and I know that we have a member for Port of Spain South, and he will speak to this as well, I'm sure. But what you have now is that if you have a person who is being detained, you may have questioning which will take place of that person, whether a charge is laid or not. So you can have questioning before, and you can even have questioning after being charged. What is the importance of it is that you have the judge's rules, and under that, Madam Speaker, there is a Rule 1 caution. Essentially, we say that what you have is you can have the right to remain silent. What is taking place, Madam Speaker, in the justice system is that despite an accused adopting the position of wanting to remain silent, as it stands now in the law, you still have a situation where the JP can be brought in by the police officers, and then questions are put to that accused person. And if not, as I indicated earlier, even if they are not charged and they are just simply being detained and interrogated, even in such a situation, what you have is they bring in the JP, and the JP now is there for the purpose of questions being administered to the person who is being detained. And that runs contrary to the judge's rules. But what is the importance of that down the road, Madam Speaker, is that you then have issues arising as to the admissibility of the evidence. So that is in relation to what obtains now in relation to JPs. This provision, Madam Speaker, now encompasses more persons other than the JP. As I indicated before, it will now include, you have the welfare worker, the social worker, and other persons as well. So you're expanding the group of persons who are now going to be approached for the purpose of sitting in these interviews
And I'm saying without proper definition of what their duties are, you can see a replica of what obtains now in relation to the GP to extend to this wider base of persons, this wider category of persons. And remember, at the end of the day, Madam Speaker, when we talk about all of these provisions, clarity in procedure is one thing, but we must have fairness, and the fairness must extend to the accused. So it is very important that when we talk about the protection of law, it will no longer exist in the absence of proper definitions. You will have more avenues being accessed by the police officers, whereby they can put things to the person who is being detained or accused following a formal charge being laid. So I say that, Madam Speaker, that an appropriate adult is new, and I mean in our jurisdiction, is new to the criminal law. So it is important that we take into account the duties, we define properly what the duties are of the appropriate, of the adult. And so, Madam Speaker, on that point, that is the example I used to cite why it is I say that you can have uncertainty leading to confusion. So, Madam Speaker, I say that the second point I want to move on to is that, and I thank the Attorney General for citing statistics, because it is important for something as important as this bill that we see in the context as presented on our statistics. So, according to the Attorney General, and not to recite or to rehash what has been said by him, we are seeing that we have 37,933 matters pending, these are indictable matters, pending before our courts, and I think that was cited as at March 2023. And according to the Attorney General, in our system, we are looking at the 37,933 matters, criminal matters, plus 8,835 indictable offenses filed annually. So you can imagine this is 37 plus almost 38,000 plus 9,000. And that takes you up to 47,000 matters existing in a system. And that is increasing per annum by almost 9,000 matters per annum. So I know that the Attorney General, heralded this piece of legislation as the fast-track trial law. The question I want to get into now is that where does the infrastructure largely come from to operate this piece of legislation? So if we were to implement these amendments to the indictable proceedings laws, where does the infrastructure come to support it? And Madam Speaker, if we are talking about a system, we are talking about, when we talk about indictable offenses, we are talking about serious crimes, murders. We are talking about paper committals. We hear the term sufficiency hearings. So you're dealing with everything largely, Madam Speaker, by way of paper. Everything is going to be codified up front in paper. And you're going to have a sufficiency hearing where they will determine whether a prima facie case has been made out. And if so, then it is going to go in the system towards a criminal trial. And if not, well, it will be thrown out. If everything is going to be by paper, who are the persons who are going to be codifying the necessary ingredients of the offense? Who are the persons who are going to largely be doing the drafting? And it comes down simply to, Madam Speaker, the office of the DPP. Yes, you will have more weight being placed on the criminal masters, the masters that sit in the criminal jurisdiction to adjudicate. But I'm talking about before it even gets to the stage of adjudication. You're going to have the police officers, one, but two, mainly the office of the DPP. And Madam Speaker, I think that it is somewhat disingenuous to simply say that, you're piloting a bill, and this is not directed individually to the Attorney General. I'm saying that it is disingenuous if you are piloting a bill like this, and you're talking about the success of this proposed system when you do not give proper credence to those who will have to be the infrastructure and the support for this implementation that we are embarking upon. And why do I say that, Madam Speaker? And I think it is critical that I cite a couple matters in relation to the office of the DPP, because I think if you are coming here to pilot this, you must have some authority to do so, whether it be moral or legal or otherwise. And I am saying, Madam Speaker, that we have, as at the 11th of March 2023, and with your permission, I refer to an article published in the Newsday. The title of the article is AG Rejects DPP's Call for More Staff, claims that the department is underperforming. Madam Speaker, without going too much into the details, what it simply says is that the Attorney General, Reginald Amor, says that the call by the DPP, Roger Gaspard, for more staff is an unsatisfactory explanation for underperformance of the DPP. This is March 2023. We are here in June 2023. It goes on to quote that the unsatisfactory explanation for underperformance of the DPP, other critical arms of the criminal justice system are also operating below capacity, yet far more effectively. We need to critically examine what are the systemic issues that are hampering the performance of the DPP's office. These are the words of the Attorney General that is quoted in this article. And, Madam Speaker, this did not rest there. This was the 11th of March, an article. And then you have, by the 15th of March 2023, I go to another article which was reported in the Newsday, and other newspapers carried it as well, but I have singled out these because it was quickly thrown up on the research. DPP's lawyers want apology for AG's criticisms. Madam Speaker, following the Attorney General's disposition, his assessment of the DPP's office, state attorneys at the office of the DPP sent the Attorney General a 2-page letter delivered to the Secretary shortly following his comments, demanding that he apologize to the office of the DPP. Madam Speaker, what is the relevance of this? You have 16 attorneys from the DPP office that are demanding an apology for making that statement. And Madam Speaker, I say that we on this side, we always stand on the side of the hardworking public servants, on the side of the rights of citizens. And I say that today we want to call upon the Attorney General, if he intends to pursue this piece of legislation, that he should outright offer an unequivocal apology to the office of the DPP. Madam Speaker, it is not us alone who have been saying that, that this should be done. There are other persons in the public domain that are of this view as well. But on the point of the infrastructure, and I move away from the apology, on the point of the infrastructure, we even had the Law Association come out during that time and say that they deem matters have reached a critical stage in the office of the DPP in light of the shortage of resources at his office. So in addressing this important bill, one would have thought that such strong words being uttered by the Attorney General, that we would have heard something today, Madam Speaker, or certainly in the first session when this bill was being piloted, as to how it is we can expect that that office will be equipped sufficiently to treat with these amendments, because we are going fully paper and front-loaded in terms of abolishing the preliminary inquiries. So, Madam Speaker, I leave that point there, and I hope that the Attorney General offers the apology. Now, Madam Speaker, I move on to treat with some of the clauses of the bill. And when we look at, I have dealt with the definition of the appropriate adult. And when we look at the other matters arising under these proposed amendments in the definition, Madam Speaker, what I want to say is that when we look at the use of the non-rewritable, so what you have is a definition now for audio recording. And what it says, Madam Speaker, is that the use of non-rewritable in this definition of audio recording, Madam Speaker, what it does is that it creates an unnecessary bar to the use of video evidence. Because when you come later in the definition section, you see a very expansive, you can anticipate an expansive definition under video recording itself. But when you look at this one for audio recording, what you see is that if a video is recorded on a medium that is rewritable, Madam Speaker, we have attorneys on both sides of the House. You can anticipate that a good defense attorney will argue that it does not meet the standard required for the video evidence to be admissible. So the question is, what is the intention of that definition? Is it that we really do not want no medium that is other than on a non-rewritable medium to be admitted or to be debarred. Because what you can have is that you will see, for example, Madam Speaker, the best evidence rule, for those who may be familiar with it, is that that is what will be put forward, admissible before a court of law. So you may have the voice of a person, an accused person, on probably a cell phone, and that voice now is on a rewritable medium. That is the best evidence that would probably be available to sustain the charges and to be prosecuted. And so if it is the voice of the accused person, you would want to know that that can be admissible. Under this definition, it will not, because it is on a medium that is rewritable. So we have to be clear what is it we anticipate, and we may have to restructure that particular definition. So, Madam Speaker, that is in relation to the audio recording. Madam Speaker, bearing in mind that I have started off by saying that you have uncertainty, and the uncertainty that I was referring to as overarching points to be debated in this bill, it can lead to confusion. So I just for the record, Madam Speaker, the answer that is audio recording means an audio recording on a non-rewritable recording medium identifying the persons speaking. So I don't repeat my point, Madam Speaker. We have to be clear exactly what evidence we want to be captured under this. And if we know what evidence we want to capture, the question is whether it will be admissible by virtue of this definition, audio recording. So, Madam Speaker, that is in relation to the audio recording. Madam Speaker, when we go along, and I take some of the clauses in order, and when we look at, for example, Madam Speaker, I look at the warrant of apprehension versus warrant of arrest. Now, what you have, and Madam Speaker, maybe I should take it in order of the bill. When we look at, this is section 4 of the Act, and it would therefore be clause 5 of the bill, where they are seeking to amend section 4 of the Act. Madam Speaker, when we look at this, in criminal law, we have instances of what we would call joint enterprise. So you can have persons who are jointly charged, and you can have offenses that you would want to prosecute by way of joint enterprise. So what you have now being proposed under section 4 is a magistrate shall not determine that a case is to be determined in accordance with this act unless the magistrate, and so they speak of subsection A, in the case of a joint trial, so determines in respect of all accused, and B, in a case where 2 or more charges are to be tried together, so determines in respect of all charges. So what is critical there, Madam Speaker, is that when you're talking about a joint trial, they're saying that the magistrate must so determine in respect of all accused. And where you have 2 or more charges are to be tried together, they're saying that the magistrate must so determine in respect of all charges. What I would say to that, Madam Speaker, is that the section is unclear as to joint trials. In the case of a joint trial, where we say determines in respect of all accused, does this mean if the case is made out against one accused and not the others, a prima facie case is not made out at all? The proposed amendment does not factor in that in some instances there may be evidence against one co-accused and not the other. So therefore you may want to proceed as against that one that you have the elements of the offense, the ingredients of the offense having been made out, and then discharging the other person. So the act is unclear as to how the magistrate is to proceed in cases of joint enterprise and where there are multiple charges. And if I may be permitted, Madam Speaker, just to attempt to break it down, you may have the evidence against 2 persons charged jointly. The legislation I'm saying is silent as to what happens if the evidence against one person is weak and therefore not worth prosecuting. Does not give the master the power to commit on the merits of one individual case. And when we talk about joint enterprise, it therefore suggests that you have to find a prima facie case against everyone charged, as opposed to you can proceed against one. So we should have in this proposed amendment where it says categorically the evidence that ought to be considered and that it can apply to an individual, and therefore not everybody has to be found who are jointly charged, be found to be making out the case and sufficient evidence before the charge can go forward. The other part about this and the other side of this, Madam Speaker, is that in our jurisdiction, we still have the legal right to elect to be tried separately. So even if you are charged jointly under our laws, you have the right to elect to be tried separately. And therefore, that must be made clear in terms of this particular provision, this amendment. Again, I say that is Clause 5 of the bill, which would be seeking to amend Section 4 of the Act. So I raise that, Madam Speaker. That is something that I deem to be particularly important. When we move away from Section 4, Madam Speaker, and then we go to Section 5, I believe in the Attorney General's conclusion in piloting this bill that the Honorable AG mentioned that we will probably see, or we would see, some amendments to Section 5 to ensure that it treats with due process properly. I don't know what that amendment is, but what I would say is that based on what the bill has proposed, my concerns, Madam Speaker, are very simple. When you look at Section 5 and the amendment that is being proposed, so that would be Clause 6 of the bill, and that would be in relation to Section 5 of the Act. And you have amendments speaking to search warrants being issued under the Act for the purpose of obtaining communications, data, stored communication, or stored data, and the reference is made to the Interception of Communications Act to apply. And they speak about the search warrant being issued by the master and search warrant issued by a person referred to in Section 10 who exercises concurrent jurisdiction. I believe the concurrent jurisdiction with the master is at Section 10 is the registrar. But what is important with this particular provision is that, Madam Speaker, under our common law, in the criminal arena, what you have is you have a system where you will seek warrants to do different things. As it stands now, you can go to the JP. The Justice of the Peace will be in a position to take whatever affidavit evidence is put forward before the JP, whatever evidence is put on oath. Sometimes you can anticipate that part is prepared on oath in writing and in the form of an affidavit, whereas they may amplify on oath certain matters orally in order to secure warrants. When you get the warrant, Madam Speaker, you can have warrants which are, it ought to be applicable to the circumstances of the case. And when I say applicable, I mean it must be proportionate to what the warrant is actually seeking. So you must not have a situation or an opening or uncertainty where the issuance of a warrant can be sought at large and therefore it is disproportionate to the rights of an accused person. And what do I mean by that, Madam Speaker? You have warrants which you can secure to seize devices. So you can actually get a warrant to seize somebody's phone, somebody's cell phone. If you want to get a warrant, if you want to now get into the information stored on that phone, that is something that is subject to a separate warrant. So you would have to satisfy that you are seeking the physical obtaining of the phone, but you're also seeking to interrogate the contents of the phone. And therefore, that is a subject of another warrant. And if even, Madam Speaker, you are contemplating that, the issue can arise that you also want to get the password, because sometimes to get into the devices, depending on the device, there are passwords, so you have to get key passwords. So the common law recognizes, Madam Speaker, that you can actually secure a warrant to get that password, and certain conditions are put forward. These, Madam Speaker, are not provisions in our common law that are to be trifled with. These are provisions which are there because it must not have a situation arising where you secure a warrant which is more intrusive than is necessary. So you don't go for draconian measures to secure information which you can otherwise secure by something less intrusive. Why do I say that, Madam Speaker, is that when we look at the Section 5, Clause 6.
Honourable Member, you have about 15 more seconds left of your original speaking time. You're entitled to 15 more minutes to complete your contribution if you wish.
Thank you, Madam Speaker. I would please seek permission to exercise the additional 15 minutes. So, Madam Speaker, I say that because what you have, you do have a Privy Council case of Brandt and the Commissioner of Police arising out of proceedings in Montserrat. The citation is 2021 UK PC 12, and that is a matter where they went extensively into what the warrants can actually do. There is also a local matter of Adrian Schoon versus the police, and that is a matter which, Madam Speaker, I know members of this House would be familiar with. I see member for San Fernando West is here, and he would be familiar with that matter. That is a matter in which the police was seeking warrants to be able to access devices, and they wanted to get the password of one Mr. Schoon, who's someone who was operating a party boat, and there's quite a history to that, Madam Speaker. So, Madam Speaker, what I say is that we should factor in, whilst the common law in different jurisdictions, you can see the development of protection for the accused in terms of obtaining warrants. We have the opportunity to codify it in our legislation here and to make the distinctions, and I think we should do that if we are moving forward with this proposed bill. Madam Speaker, I go to next, that would deal with Section 5 of the Act, Clause 6 of our present bill. I would go to next Section 6 of the Act, and that would now relate to Clause 10 of our bill. And then we would see that we have certain amendments that are being made to Section 6 of the Act. What Section 6 proposes, Madam Speaker, is that you can have where a master, if he or she is satisfied that there are grounds for believing that an indictable offense has been committed, issue a summons or an arrest warrant to compel the appearance of the accused before him. What is troubling with this provision, Madam Speaker, is that the definition that is being provided here, the ground that is being provided here for the master issuing a summons or an arrest warrant to compel simply the appearance of the accused before the judicial officer. It simply says if the master is satisfied that there are grounds for believing that the offense has been committed. And Madam Speaker, when I looked back, I saw that my colleague, member for Barataria Sawan, had raised this in another debate, in another place, and I would just find quickly the reference where that was raised, because what is important was that the member had raised that you should not have something as simple as saying that there are grounds for believing. And so that is something, Madam Speaker, if I can get my note, it is certainly too low a threshold to allow the master to be able to issue something as serious as a summons to compel arrest or a warrant to procure someone to attend before the court. And I say that, Madam Speaker, because it is very important. These are all going to give the officers powers to compel persons to come before the court. And I think we need to get that definition right. Madam Speaker, we have a situation where it ought to be that you are reasonably satisfied or that you have reasonable grounds. Simply saying that you have a situation and you are going to utilize the test where there are grounds for believing is too low a threshold. And why I raise it, Madam Speaker, is that this was raised in other, if I do get my notes on it, Madam Speaker, I will return to it. But I know that it was raised before. It was possibly a joint select committee when we had the undertaking of the member for San Fernando West then that it would be corrected so that we would have the inclusion of reasonable grounds for believing. That now elevates the test, Madam Speaker, and we need to be careful because we are talking about a summons for or an arrest warrant being issued against someone. So, Madam Speaker, I say that very quickly in passing because we need to get these terminology and we need to get these procedures right. So, Madam Speaker, that is in relation to the arrest warrants. One of the things I want to mention as well, Madam Speaker, is that what you have is we must make provision in the law, and this is something that I am not seeing in this act, provision whereby the proportionality test is something that you must not be left to ponder. It must be evident on the language that the law provides. And so this is something that I am not satisfied that we have sufficient protection when it is you want to compel someone just simply saying that you have grounds for believing. So, Madam Speaker, I say that. I turn to Section 4 of the Act, whereby we are seeking to amend that to include the term that the magistrate, in the interest of justice and fairness to the parties, can do certain things. And what that means is that it will be too wide for modern legislative drafting to simply say that you want to have a provision that the magistrate shall determine whether a case is to be determined in accordance with the Act. And you have just this general subheading, in the interest of justice and fairness to the parties. We need to give some direction as to how an exercise of discretion should be employed under this particular section. I refer to specifically Section 4 of the Act. The proposed amendment will be a subsection 2. And what that means is that we are being too wide. Where there are two accused persons, you have a situation where the court is required to look at the evidence of each accused person. You want to determine if, in the interest of justice and fairness to the parties, we should give some guidance what subheadings can apply under that. We are dealing with modern legislative drafting in the criminal arena, Madam Speaker. And I am saying that if we are moving forward, we should get these things sorted out now. Madam Speaker, the other point I want to turn to quickly is that, for example, when we look at I have dealt with the joint trials. When you look at, for example, the proposed amendment of Section 6, where a complaint is made and the accused is a child, the entire process does not accord with the spirit of the Children's Authority Act. Because what you expect is this multi-agency protocol and the interagency protocols to kick in. And this has been adopted by the Trinidad and Tobago Police Service and the Children's Authority. So what you expect here, Madam Speaker, is that you would see something in the bill that would point to the diversion techniques for a child who is charged with, for example, a summary offense. So what obtains in practice now, Madam Speaker, is that if a child is charged, it could be probably in Arima, it could be in Diego Martin, it could be different parts, Shoguanas. So you would have that when they are picked up by the police and they are to be charged, they are not necessarily taken to the nearest or the closest police station. They are taken before we have processing centers. Right now, to my knowledge, we only have 2 processing centers for the children, one in Oropouche and one in St. Joseph. They are at these processing centers. What is expected, Madam Speaker, is that a different procedure. The children are treated differently, and they are then taken before the children court and they are monitored. So we have to be clear in this bill that those diversion techniques that we would see applying under the Children Authority Act and otherwise, that they are also replicated here, and it is clear that anybody who is charged, a child, that they will have access to these diversion techniques that we are seeing. And what does diversion techniques mean, Madam Speaker? Very simply, they may not necessarily have to go through the formal processes and the extent of the full brunt of the law, but they are somehow counseled and they are monitored and in a manner that they would not necessarily have to carry the weight of the law on their shoulders. But yet, they would be monitored so that they are expected to abide by the law. So I say that because when we look at the definition section again and we see the use of prison to include rehabilitation centers, Madam Speaker, it goes against the grain of the United Nations Convention on Human Rights, and particularly rights of the child, where it clearly contemplates, Madam Speaker, that we don't use, for example, terminology like prison when we are dealing with children. Yet in this, we are seeing prison in this act is to include the rehabilitation centers. What is the reason for including this within the definition, Madam Speaker? I do not know, but it does not accord with the Children's Authority Act. A child is not to be kept in a prison, and I don't think that this act is saying it, but I'm saying terminology-wise, we would not have on the books that a child is to be even referred to as being kept in a prison. They are expected under law to be kept in a rehabilitation center. So why are we changing definitions and we are going against the spirit of the law that we are already practicing under the Children's Authority Act? And the case on that point is well known as Brian C. Prasad, a Privy Council case. Madam Speaker, we have to take into account police prosecutors versus the DPP's office. This act contemplates the use of the police prosecutors. There has been a movement, so to speak, Madam Speaker, against the use of police officers as prosecutors, and largely because there isn't anything personal against the police officers prosecuting, but largely because you expect that when you are dealing with the higher end or the more serious offenses, that they may not be particularly legally trained, even if they may have, some of them may now have their law degree. It is something that whether they have actually practiced, as opposed to those who are actually within the bosom of the DPP's office. So they do not have the experience to prosecute the more complex matters. And when you have matters involving children, you have to have specialized knowledge as to how to treat with them. So I say this because what you will now have is that you're putting them in the hot seat, as we say, Madam Speaker. We are talking about sufficiency hearings, more work. We are talking about more serious crimes, murders. Everything is by paper. And so we are saying that we should consider whether we are going in this direction or whether we want to really ramp up the resources in the DPP's office, give them what they need, have the supporting staff, have the supporting counsel, advocates, and therefore they are the ones who will be able to treat with the situation. Right now, Madam Speaker, we encounter in the courts a situation where, for example, you have officers who are the prosecutors, and when they go to court, if the virtual complainant, being a fellow police officer, does not come to court, there is nothing that can actually be done, and cases are actually being thrown out because of that simple situation where an officer fails to appear. And so, Madam Speaker, the difference between that and the DPP's office is that there is some level of the DPP's office having some authority where they can exercise, and on the instructions of the DPP's lawyers, you will see these officers coming to court. If they miss one, you can expect that they come on the second occasion. So, Madam Speaker, all of these things are practical permutations which I don't see being reflected or considered in the proposed bill, the amendments that we are seeing being proposed today. And I want to say that it is something that we should take on board, and we should be clear if we are going to implement a system which is going to outright get rid of preliminary inquiries. We want to know that the system which we are adopting, preliminary inquiries as it stands now, it is causing backlog of cases. You want to get rid of it because you're saying that the system that will now replace it will now speed up the administration of justice. We will clear up the backlog. It means that we have to be clear that the processes will not just simply create a bottleneck, remove bottlenecks from where it exists in the present system, but put it further down the road in the new system. And therefore, you don't want to have a situation like that arising. Madam Speaker, how much time do I have remaining, please?
You have about 1 minute and 30 seconds.
Thank you, Madam Speaker. Madam Speaker, I want to say that there are cases, there are reports, and one of the citations that I referred to earlier, let me just quickly say the Newsday article, and this is one which is entitled, Court Dismisses Protest Charges Against Fuad Abu Bakr. I'm trying to find the actual date of this article, but it's a Newsday article, and it spoke about the absences of police officers who were to appear before court, and that is what their failure caused the charges to be dismissed. Madam Speaker, in concluding in the short time that I have, what I would want to say, Madam Speaker, is that if we are moving forward, we should have where after all that we say here is said and done, more is actually done. And I want to say that if we are talking about moving forward, you will hear problems that we still encounter where police stations are missing diaries, police officers are taking notes in their phone. All of these problems still plague us. We need to move to a system where you can have support from proper technological advanced systems, devices. The police officers must be equipped in a manner that they can actually promote the spirit of what is being proposed here by way of the amendments. And DNA analysis takes center stage. So I think that, Madam Speaker, with these few words, I would want to say that as I started off, conceptually and as a matter of principle, we would support abolition of preliminary inquiry, but we do not want to jump from the frying pan into the fire. Thank you, Madam Speaker.
Member for San Fernando West.
Thank you, Madam Speaker. Madam Speaker, I rise to join in supporting this bill. I wish to commend the Honourable Attorney General for an excellent pilot and for putting things into the context that we are to consider. Madam Speaker, we are here as the Parliament, pursuant to the Constitution, Section 53, to make laws for the peace, order and good governance of Trinidad and Tobago. We propose today to make the final broad amendments required to the Administration of Justice Preliminary Inquiries Act, sometimes referred to as a JIPA, specifically after having had a journey to get here and a context in which this happened. Preliminary inquiries, Madam Speaker, have been around since 1917 in our laws, Chapter 1201. The very important law which runs alongside this used to be largely just the Criminal Procedure Act, that is Chapter 1202. But in arriving at today's juncture, it is important to remember that the government has spent 8 years radically reforming the system in which this law operates. Now, my learned colleague for Chaguanas West raised the question, and he asked, the honourable member asked, what were we going to do in terms of the administration and system of this law? In fact, he then went on quite remarkably to demand an apology from the Honourable Attorney General in relation to the office of the DPP, because so severe was his view about the system that the honourable member, really being new to this House, perhaps has forgotten the history of his own party, especially whilst in government, and I'll come to that in a moment. Madam Speaker, this bill, which amends the AJIPA, the Administration of Justice Preliminary Inquiries Act, comes after we created divisions of court, specifically the Children's Division, the Criminal Division, which operate in a de facto civil division. We, of course, have the Family Division, which is part of the Children Division in terms of legislation, but a separate administrative function. This law comes today after we passed the method and the subsidiary legislation in the form of rules, criminal proceedings rules. This law, in answer to my colleague's question about the system in which it's going to work, comes after we amended the law in relation to the selection of judges. We as a Parliament amended the law such that judges can come from more than the Commonwealth. This law comes after we amended the Supreme Court of Judicature Act, and we raised the number of judges in operation, moving from 36 to 64 in the High Court, and moving from 12 in the Court of Appeal to 15 in the Court of Appeal. This law comes after we amended the law to raise the age of retirement for judicial officers from 65 to 70. This law comes after we did the amendments to the children's package. And I'm laying this groundwork because it's going to come in direct answer to the submissions made by Chaguanas West. So today, we are reflecting upon a law to move away from a few very particular ills in the preliminary inquiry, Chapter 1201 law. What is a preliminary inquiry? A preliminary inquiry is intended to achieve two purposes. One, to allow the accused the knowledge of exactly what he's accused of, and 2, it was intended to be a filtration system to make sure that only bona fide matters proceeded and that things were vouched by evidence. That, in our system of justice, resulted in significant decade-long delays. The Honorable Attorney General has put on the record our statistics. Madam Speaker, there are 37,933 preliminary inquiries outstanding. That number, Madam Speaker, as the Honorable Attorney General has told us, has 8,835 per year coming. Now, Madam Speaker, when we came into government in 2015, and in relation to the infrastructure and development and the law that we're debating today, the caseload was approximately in the magistrates' court, including some 8,000 preliminary inquiries every year. It was 141,000 matters per year, 104,000 of which were motor vehicle and road traffic offenses. And in answer to what are we doing in terms of the infrastructure, it is now a matter of law and working record that those amendments to the Motor Vehicle and Road Traffic Act contained in the criminal division have moved criminal offenses for Motor Vehicle and Road Traffic Act to violations. And therefore, 104,000 cases are now treated differently. Madam Speaker, we added to that the amendments to the Dangerous Drugs Act in the decriminalization of cannabis. Some 8,500 matters per year removed as a result of that. So today, Madam Speaker, with an improvement of masters from 2 masters in 2015 to 18 masters in 2023, with a number of 25 in total, in increasing the number of judges, increasing the judicial retirement age, separating the divisions of court, creating specifically an entire regime for children and children matters, that is criminal offenses against children, where the children are accused in those courts. Children matters, in particular, are treated within a separate court. So, Madam Speaker, the amendments here today are properly in a context of significant reform. Relative to Chaguanas West telling us that the government must apologize and that they stand up for people who are working in the system. Madam Speaker, why that is to be rejected completely is borne about in a legal notice. The legal notice number 348 of 2012 saw the proclamation of this parent act, the Administration of Justice Preliminary Inquiries Act, by that legal notice, Madam Speaker, on the 31st of August 2012. How could Chaguanas West be telling us, apologize to the country for increasing all the resources I have just named, more courts, more divisions, more masters, age of retirement, children's package, and the honourable member has the temerity to forget that his government, now the opposition, proclaimed Section 34 in particular of this Administration of Justice Act when there were no masters, no criminal proceedings rules, no amendments to the law, no courts. Today we have a High Court with its criminal division at the old Hall of Justice. We have a civil court at the waterfront. We have new courts at O'Meara. We have virtual courts. Madam Speaker, for the record, the opposition senator then, Senator Wayne Sturge, went to court and challenged and lost in relation to challenges on the constitutionality of the criminal proceedings rules. Madam Speaker, every step that the government has taken to improve the system has been met with legal challenges by the opposition, most of which have failed and burnt into dust, Madam Speaker. But Madam Speaker, today we are talking about an amendment to the Administration of Justice Preliminary Inquiries route. And I want to get now, after saying there's no apology necessary in relation to the system of justice, I also add to that, Madam Speaker, that by amending the Police Service Act as we do, as a consequential amendment in this bill by ensuring that police prosecutors are persons who are legally qualified and comply with the Legal Profession Act. We are therefore easing the load of the DPP's department, Madam Speaker. Now, Madam Speaker, my friend, the member for Chaguanas West, raised the issue of the appropriate adult and said that this was effectively something which was unknown. It was something that needed to be put into this law in particular form. I would like to refer the honourable member to Section 3 of the Children's Act. I would also like to refer the honourable member to Section 51 of the Children's Act. And why I do that and why I reject the argument that we are running against the grain of the United Nations and the manner in which we treat children is that, Madam Speaker, we created by law, this government, the Children's Division. We created the Children's Court. We created the deviation techniques to move into the drug enforcement arena and the drug treatment court, Madam Speaker. And this preliminary inquiry, removal as a fast track, as the Honourable Attorney General correctly characterizes this law, what we do is we say the obvious. This law must be read in tandem with the Children's Act and with the Children Division, Madam Speaker. So it is incredible for my learned friend to say that this law is somehow in conflict and needs to be particularized. I want to remind, Madam Speaker, that the Act itself sets out, the Parent Act which we seek to amend, and in the bill which touches some of those amendments, that this law operates on the back of the criminal proceedings rules. Section 32 of the Act says, Madam Speaker, that the Rules Committee can make rules, and the rules of court are subject to negative resolution, and we have the children's rules, and we have the criminal proceedings rules, Madam Speaker, and there is no way that you can find yourself in jeopardy by not having an actual definition in this Act, which is framework law, for an appropriate adult, because it is described and set out in Section 3, and it is cross-referenced in this law, Madam Speaker, as well. Madam Speaker, my learned friend raised the issue of joint enterprise. And permit me at this point to say, the bill seeks to remove certain significant pitfalls. The bill, number one, removes the obstacles of cross-examination and examination of persons at what is known as a preliminary inquiry. Now we're at initial and sufficiency hearing. So no more preliminary inquiry. We have an initial hearing. We have a sufficiency hearing. The problem in the existing law, put very simply, one of the main problems was the examination and cross-examination of witnesses who appeared at the preliminary inquiry stage, which took years, Madam Speaker. That defeated the intention behind the 2005 amendments to deal with paper committals. And what we seek here, Madam Speaker, in answering my friend's question and in looking at Section 4 of the Act, I want to put on the record, we are treating with the application of the law. That's to be found in Section 4 of the Parent Act, Madam Speaker. And one is bound to look as well at Section 32A of the Parent Act. And Madam Speaker, our clauses of the bill treat with amendments to both of these. In particular, Section 32A is amended by Clause 38 of the bill. Now, Madam Speaker, when you look at the application of this law, we are saying in relation to one of the other main issues for delay, this law is carefully designed so that we are no longer having a dispute as to whether an old matter under the old law, the law which is to be repealed, that is Chapter 1201, whether that person is going to continue ad infinitum in the old system. We put the judicial discretion on the magistrate. In fact, this is one of the few occasions in this Administration of Justice Preliminary Inquiries Act that you're going to see the term magistrate. We put the magistrate to consider the determination as to whether the old matters can be brought under or be continued under the new AJIPA. But we do that after due process is exercised, after the prosecutor and the accused are given the opportunity to be heard, and with the interest of justice and fairness to parties as a consideration, which is an overriding condition precedent. The magistrate must also obey the direction that no case is to be determined unless in the case of a joint trial, there is a determination in respect of all of the accused. So my learned friend is saying in his submissions, Chaguanas West, that we are wrong in the statement of law that we put before this House because we have, according to the Honourable Member, omitted to treat with the particularized details of joint trials and joint enterprises. I want to say in answer to that, this is framework legislation. If you go to section 32 of the Act, you will see that the rules deal with the prescriptive aspects pursuant to this Act and under the Supreme Court of Judicature Act, under the Criminal Division, under the Children Division and Family Division as well. They all feed into that same source, Madam Speaker. And I want to remind that the court overruled and denied the application by one Senator Wayne Sturge to hold the criminal proceedings rules as in violation of the Constitution and law. So that law stands. In the case of David O'Brien. Madam Speaker, so the joint trial issue and the allegation that we're somehow wrong just doesn't arise if you listen to the contribution of my learned friend, Chaguanas West. Now, Madam Speaker, the Honourable Member went on to treat with Clause 6 and dealt with the warrant to seize. And Clause 6, the Honourable Member pointed again to issues about we need to have concern because you can get the device, but you would have to take a separate warrant to get the information. I'd like to refer you, Madam Speaker, when we look at Clause 6 and we look at Section 5A of the parent law, you will note, Madam Speaker, that we're making an amendment and we're specifically cross-referencing the provisions to the Interception of Communication Act. Right now, we don't need to rely on the common law for the warrant to produce a device or the information. We actually have the existing Chapter 1201, Section 5, where you can get a warrant for the production of the device. But we also have the Interception of Communication Act, which specifically allows us to get the data, the communications data, the stored data, Madam Speaker, as well as the stored communications. You will see, Madam Speaker, in the amendment proposed by Clause 7 that we are asking for communication data, stored communication, or stored data. So contrary to the submissions of Chaguanas West, we have not missed anything out. We are specifically capturing the 3 species of data, that is communications data, and stored communications. Those can be obtained by a warrant. But Madam Speaker, we are doing more than that. Number one, as we are talking about passwords, we don't need to refer to school or any other matters. The law is right here. And if you're looking at passwords, Section 13(2) to 4 of the Interception of Communication Act, which is included by way of Clause 7, specifically say that third parties who have things like passwords, etc., under penalty of law, a summary offense is the penalty at law, Madam Speaker, $1 million as the summary offense if you fail to cooperate with the warrant, Madam Speaker. You are subjected to that cost, and that includes internet service providers.
Member for San Fernando West, you have 1 minute more of ordinary speaking time. You're entitled to 15 more minutes to wind up your presentation.
May I please respectfully take that time?
You may proceed.
Yes, Madam Speaker. So specifically, we have included, contrary to the submissions of Chaguanas West, the specific reasons and ability to obtain the warrants and structures, etc., Madam Speaker. Now, Madam Speaker, that means we get device, we get information, we get structures. I believe the Honourable Attorney General has a few thoughts in relation to any amendments that may be required on that, but I think it is to capture the species of stored data only. Madam Speaker, the reference to child, and the allegation in relation to the description of prison. The honourable member said, for Chaguanas West said, that we were running contrary to the United Nations and our position by using the term prison. Now, Madam Speaker, you will see that in the amendments to Section 4 of the Act that we ask, we do amend the term prison, and we specifically cleave prisons from child rehabilitation centres. And we are very well familiar with child rehabilitation centres. What was kind of interesting that Chaguanas West put forward was reference to the case of Brian C. Prasad. It's actually Brian C. Prasad and Sasha C. Prasad. It was a case brought by Attorney General Anand Ramlogan in new clothing, now as attorney at law for those two parties, where the case came to say the proclamation by the government to put on child rehabilitation centres as a mandatory thing, that children must go to centres and not to prison, was deficient because there were no child rehabilitation centres. And they asked for damages for failure of the government to do that. What was missing from the proceedings, for which the Privy Council took note of, was that the person that proclaimed the law was the Attorney General of the government that failed to bring about the child rehabilitation centres and then exposed the taxpayers to millions of dollars of costs and damages. Madam Speaker, it is just mind-boggling that somebody could have the moral position of doing what the past Attorney General did, and worse yet, for his honourable colleagues in the party, because they celebrate that this is the best Attorney General they've ever seen, that they would hold it up as an example, Madam Speaker. I mean, common sense and morality just dictate against that, Madam Speaker. Madam Speaker, as a matter of fact, the reason why prison is done that way is that specifically if you're dealing with children, as I mentioned before, this law must be read with the Children's Division and Family Division and with the Children's Act. And if you look at it, Madam Speaker, you will see the Commissioner of Prisons is in fact the person with authority over children in child rehabilitation centres. And that reference to prison is because, Madam Speaker, we are amending 2011 law. Let me remind, in 2011, I sat in opposition, debated the preliminary inquiry's new version at JIPA, saw it proclaimed with Section 34 only in 2012, saw the move to the Antigua model come up in 2014, and then had to experience the Privy Council saying that it was effectively madness for Section 34 to have been proclaimed the way it was. But the journey on preliminary inquiries really involved masters to be provided, new courts to be provided, and criminal proceedings rules to be provided, none of which existed in 2012, all of which now exist in 2023. So we are coming with a very different matrix before us now, Madam Speaker. And Madam Speaker, that is why the reason for the use of prisons is done the way it is. Now, Madam Speaker, I'd like to also put on the record that if you want to look at the big architectural points, because this is actually wonderful law in respect of which we could talk about each and every one of the clauses. Each clause is rich in content, Madam Speaker. This bill proposes underwriting electronic filing. This bill proposes that we don't have to go to Mars and Venus, etc., to come back right here to the planet Earth. We have to treat with the truth of our management of system. The truth of our management of system is that electronic filing is now a reality. The truth of this system is the bugbears involve, number one, the time frame for the filing of the indictment. If you want to exercise maximum sentence indication, if you want to enter into a murder felony plea, if you want to use plea bargaining, if you want to say, I am guilty at sentencing, you have to enter the plea of guilt and then be referred to a judge for sentencing. A vast number of persons who are on remand and a vast amount of the cases, the some 39,000 cases, etc., involve the fact that there's been significant complaint that the indictments are taking too long, either to work their way through the system because of the obstacles of cross-examination and examination, or that when the committal bundles are ready, that the process of the indictment being perfected takes too long. And this bill, in proposing amendments specifically targeted at the indictment, significant discussions were undertaken, Madam Speaker. Madam Speaker, I moved on behalf of the government in my tenure as Attorney General at least 4 amendments to this law. And in each step of the way, we had significant consultation, Madam Speaker. Consultation with the judiciary, the Public Defender's Department, which interestingly, Madam Speaker, this government created. We dealt with the issue of the lack of defense attorneys, the small criminal bar, by creating what is now an incredibly successful Public Defender's Division, Madam Speaker. You know what was quite curious? The senator who sat opposite me then, in relation to the Criminal Division Bill and the work that we were doing for the UNC, and who had certain reflections, is now the head of the Public Defender's Division, and can testify that this government deals without malice, deals without fear or favor, but more importantly, Madam Speaker, can testify to the merits of the law that we passed. Madam Speaker, when we passed the Criminal Division Bill and the Family and Children Division, the opposition was up in arms to say nobody would go to court virtually, Madam Speaker. That is now a standard feature of the operation of our courts, Madam Speaker. So, Madam Speaker, in treating with submissions coming from the judiciary, the public defender, we also had the Office of the Director of Public Prosecutions, the Trinidad and Tobago Police Service, but importantly in 2021, in the middle of the pandemic, we reignited under the Chief Justice's Committee the sector that treats with discussions on this. And Madam Speaker, I'd like to say that there has been at least 2, nearly 3 years of clause-by-clause analysis with flowchart information as to every step of the way, which is bound to also capture all of the other amendments we made. So, Madam Speaker, when we are talking about the delays in the system, the filing of the indictment, there was a point in time when indictments could not be filed because transcripts could not be produced. Madam Speaker, there was a backlog of approximately 10,000 transcripts. That went to 0 by the use of new technology, by the use of voice transcription, Madam Speaker. So, Madam Speaker, there has been a massive operational improvement in the judiciary. As we get to this now, and we're talking time frame, and we're talking indictment, I want to start off by pointing that the amendments to Section 11 of the Parent Act, Madam Speaker, are critically important to us. Section 11, Madam Speaker, is reflected upon in Clause 13. And in Section 11, Madam Speaker, I would like you to notice that when we're dealing with, that's Clause 15. When we're dealing with Section 11, we are upfront requiring the indictment to be considered. And I'd like to point you, Madam Speaker, to Clause 15b, Roman 4, and I'd like you to note that the prosecutor shall file in the High Court and serve on the accused the indictment. That, Madam Speaker, is really, even though it is a very simple inclusion in Roman 3 of just the words the indictment, and that is the genesis of the solution. Because the indictment was a creature just floating around. There was notice being given, but the indictment was elusive. It was so elusive that we had to include, but which we're repealing today, that you had to file the indictment within 12 months, or else a delay application could be filed, and you could go for a discharge, and that discharge was set out with exceptions in the 6th schedule, which we're repealing today. Because, Madam Speaker, that, if I translate it for the ordinary person paying attention today, that was the genesis of Section 34. They used Section 34 to say, it's 10 years old, we're out of the system, Madam Speaker. And then that would have been added on by the delay provisions which we're deleting today. So there is a massively important inclusion of the word "the indictment" into what is now Section 11 of the Act, pursuant to Clause 15, Madam Speaker. And Madam Speaker, there begins the process. The Honourable Attorney General referred us to the removal of concurrent jurisdiction of magistrates. Madam Speaker, we had this confusion. You have a summary offence, you're going to the magistrates' court. You have a triable either way, you're going to the magistrates' court. You're arrested, you're supposed to come to the master, but you go to the magistrates' court. All of those things have been removed in this bill. If you are indictable, if it is a triable either way, it must start indictably, you go to the master. If you have a summons, you go to the master. If you have a warrant, you go to the master. If it is a voluntary indictment by the DPP, Madam Speaker, you go to the court and you also subject that to the sufficiency hearing and initial hearing, Madam Speaker. So this law, some 10 years later, 12 years later, Madam Speaker, is on the back of massive amendments to our system. So the indictment is the key point here. Now, Madam Speaker, another critical issue which raised its head for us, apart from the indictment, is the fact that we look at Section 23, Section 24, and Section 25 of the Parent Act. And Madam Speaker, if you look at Section 23 of the Parent Act and you cross-reference it to the clauses of the bill, Section 23 of the Parent Act is amended by Clause 23. And Madam Speaker, you will see that this is where we are treating with, if you start at Section 20 of the Parent Act, which is Clause 22, Section 21, which is Clause 23, Section 23, which is Clause 24, you will see here the master in conducting the sufficiency hearing, Madam Speaker, is bound to use modern technology, the marking of exhibits electronically. Madam Speaker, I can tell you this, having participated in a trial abroad recently, I was quite impressed with the electronic system of marking used in US courts. The use of video testimony and video depositions in US courts for people who were now deceased or had now become mentally incapacitated. The techniques that caused success in that Piarco matter in the recent proceedings in Miami actually find themselves in the body of this bill. Video evidence, audio evidence, depositions which were taken prior flowing into the statement, but it really starts and stops with where the indictment goes. Now, Madam Speaker, if you look at the consequence of the indictment, I'd like to point out that the indictment is a critical tool because the indictment is actually something which is generated by the state, in this case, the DPP. Prior to the 1975 Constitution, it was the Attorney General. In 1975, we put that in the sole discretion of the DPP. We created Section 90 of the Constitution, 76, forgive me. So, Madam Speaker, when we look at the powers of the DPP inside of here, the Criminal Procedure Act, Chapter 1202, really the factor of the DPP signing the indictment is only a creature of the second schedule. And if you look at it, the purpose of an indictment is to tell you what is the charge you're facing with sufficient particularity so that you can defend yourself. It goes along with the rules of disclosure, the rules of evidence, no longer common law rules alone, but codified in the Evidence Act, Madam Speaker. And when we look at the provisions there, you will see that we are now harmonizing the approach, making the prosecution and the defense funnel all their submissions into court. We're removing the cross-examination of witnesses specifically at the sufficiency hearing stage, except for one type of person. And that is only with the leave of court. And the one type of person is somebody who has an unsworn statement, because that is sometimes a feature which happens. So, Madam Speaker, not only the failure to file the indictment has been treated with, but now we're treating with the consequence of the transmission of documents being set out. Because when you get to the sufficiency hearing, you look to the provisions that treat with the transmission of documents, you will notice that everything that forms part of the record of proceedings is at the court or at the police or by the direction of the court held. So, Madam Speaker, this law now contemplates a virtual environment where your documents cannot be lost. And therefore, the certainty of your options now look better. You can't plea bargain unless you have a proper record. You can't enter a guilt on an MSI matter unless you have a proper record and you have the indictment. The court must be properly seized of all of the material. We've removed as well the need for the recognizance of the witness at every stage of the matter, because at the witness statement stage, the recognizance is entered, and this bill does this as well. Madam Speaker, it's 10 minutes left, yes? Much obliged. Madam Speaker, the law before us now also, at clauses 35, clause 32, catches up with a few amendments to the law. My friend, the Honourable Member for Port of Spain South, participated in St. Omer and Achille Charles. That law set out the challenges to the exclusion of the right of the accessing bail in matters of treason and in capital offences, that is for murder, etc. And Madam Speaker, therefore, any reference to non-bailable, etc., in clauses 35 and 32, as they reference section 28D and section 28, you'll see that we're treating with that, Madam Speaker. And therefore, we're harmonizing the approach. It's the same harmony approach that I refer to as we're treating with the Children's Act, the Children's Division, the use of the child rehabilitation centers, etc., Madam Speaker. It's the same thing. One of the problems was the binding over of witnesses. I refer you to clause 37, which treats with section 30. We are now binding over witnesses, and you'll notice, Madam Speaker, in keeping with the structure of our Constitution, the independence of the DPP, the features of section 90 of the Constitution, we are referring everything, if you are committed for the trial after a sufficiency hearing, Madam Speaker, you are going under the provisions of the Criminal Procedure Act, Chapter 1202. That means the DPP has conduct of that. Now, Madam Speaker, if we break it down, where do we stand right now? This law contemplates the operationalization of a new system. Back in 2015, when we came into government, there were 2 masters, 34 judges, a Supreme Court which comprised the High Court and the Court of Appeal. The Magistrates Court was run with a clerk of the peace who was a public officer and not a lawyer. There were no recordings virtually done. There were no registrars in the Magistrates Court. There were no judicial support officers. Madam Speaker, children were locked in with adults. You had 104,000 motor vehicle and road traffic cases, 8,500 marijuana cases, 26,000 preliminary inquiries coming at you every year, 40,000 preliminary inquiries, Madam Speaker, and all you had was the opposition turning on Section 34. Fast forward 8 years, you now have a criminal division, a family division, a children division, a civil division. 36 judges have moved legislatively to 64. High Court, that is. Court of Appeal, you move from 12 to 15. The age of retirement has moved from 65 to 70. You have criminal proceedings rules, criminal procedure rules, which the opposition tried to negative and challenge constitutionally and lost in court. Madam Speaker, you now have a system where violations operate and your backlog is being managed in a magistracy. It's now called a district court. You have the district judges. They have the support of judicial support officers, judicial research assistants on a 5-to-1 ratio. All of the proceedings are managed electronically, Madam Speaker. We have taken the lessons learned in preliminary inquiries, which had to be restarted because of magisterial issues or retirement or other factors. We have taken the benefit of the learning in Section 23(8) of the Preliminary Inquiries Act, Chapter 1201. We've added that into this mix. We come forward now. We have taken the fact that exhibits can be recorded by way of photographic evidence. Third parties can receive their exhibits back. But Madam Speaker, I want to also point out that we have brought significant attendant information attached to the protection of witnesses, Madam Speaker. And it is very important to note that the only time that a witness is not required to attend at court, Madam Speaker, is in certain circumstances. Unavailability of the witness beyond the jurisdiction of the court, but very importantly, this bill says, if there is danger to the witness, and if there is danger to a member of the family of the witness, Madam Speaker, that the court can, in its discretion, consider the admissibility of witness statements or evidence. Now, Madam Speaker, could you imagine if this opposition were to put right before wrong and actually support the provisions of anonymous witness evidence, the provisions of whistleblowing protection, Madam Speaker, allow witnesses a fighting chance, allow them to give their evidence by the use of deposition testimony, allow for the transmission of those documents, Madam Speaker, directly to the court, and the transmission to stay by way of record of proceedings. Madam Speaker, we will be bettering the system of justice. But the opposition wants to see us run, as Minister Hines often tells me, in a 100 meters race, they want to see us run a brisk 99 and then trip you on the line. And Madam Speaker, when you look at the need for bail amendments to stand, when you look at the best class that we could do for anti-gang provisions, etc., when you look at the provisions that we brought as a government to treat with possession of firearms, if you get caught once, that you should be reversing the burden of bail. In other words, then, we are demanding that people who are caught with firearms explain why they should not receive bail. Not that we take away their bail. The opposition stands against that. And then they are the ones up and down the country celebrating gore and death and mayhem and saying the government won't do anything about it when they will not participate where they can, which is in the Parliament of the Republic of Trinidad and Tobago, under Section 53 of the Constitution, where we make laws for the peace, order, and good governance. Madam Speaker, the Administration of Justice Preliminary Inquiries Act is ready to rock and rule. The Honourable Attorney General has spent a lot of time in pruning the final positions on this. We as a government bring before this Parliament now 8 years of work. The Privy Council decided in Hilroy Humphrey that there's no right to a preliminary inquiry. You have a right to a fair trial. Madam Speaker, we have a method to get there. This will trigger plea bargaining. This will trigger maximum sentence indication. This will trigger ease and better access to justice, Madam Speaker. And by the amendment to the Police Service Act, we are also therefore broadening the participation of the prosecutors to include prosecutors from the Trinidad and Tobago Police Service, Madam Speaker. Prosecutors to go behind trafficking in persons. If you look to where the voluntary indictments exist, Madam Speaker, where the DPP can take action, we are signaling to the country our disdain for trafficking in women and children. And trafficking in persons is center point to that. I am sure Caroni Central is interested in that. I'm not afraid of it, Madam Speaker. Madam Speaker, these are the kinds of things that they want to stand in the way of, Madam Speaker. And I just ask why? Why, Madam Speaker? Why would Caroni Central stand in the way of that? So, Madam Speaker, I believe that I have 1 minute left. And in that 1 minute, despite the protestations of Caroni Central, Madam Speaker, I'll say that this law is ready to rock and roll. We support this law. It will involve the fast-tracking of cases, Madam Speaker. I stand behind the Honourable Attorney General, who is having received this baton, carrying it with with strength and pride and making good pace, Madam Speaker, and we collectively as a government, Minister Hines pushing national security and prosecution, improving the prosecutorial capacity of the Trinidad and Tobago Police Service, because, Madam Speaker, my colleague, the member for Laventille West, the Minister of National Security, you see, people don't like to see good things, so they like to pour scorn, Madam Speaker. I could testify for his work and ability and in improving the prosecutorial power of the police in particular. And Madam Speaker, I support this law. Thank you.
Well done.
Honourable members, before I call on the next contributor, I just want to take the opportunity to correct the record having regard to the premature warning which was given to the member for San Fernando West. His ordinary time expired at 3:45:50. So the additional 15 minutes would have carried him to 4 o'clock and 15 seconds. Member for Barataria, San Juan.
Thank you very much, Madam Speaker. Madam Speaker, before I begin my substantive contribution, I just would like to take the opportunity to wish all my brothers and sisters in the Muslim community Eid Mubarak. Some of my brothers and sisters are celebrating Eid today, Eid al-Adha, and some will be celebrating tomorrow. So I take this opportunity to extend Eid greetings on behalf of the opposition bench in Trinidad and Tobago. And Madam Speaker, San Fernando West said when he ended his contribution that this law is ready to rock and roll. Madam Speaker, this government had rocked the criminal justice system and rolled it down a hill. That is what they have done with the criminal justice system. Because they have caused a system that had issues to now become a system that is almost on the end of its life. It's almost coming to a grinding halt because of mismanagement, because of incompetence, and because of a lack of resources and attention being paid to the criminal justice system. You see, Madam Speaker, this government is a reactive government. They only take action or attempt to take action when there is already a problem. There is no proactive steps being taken by this government in order to fix the system. The system is bad. All of us admit that the criminal justice system is bad. And just yesterday, there's an article coming out from the Newsday, man guilty of killing ex-wife sentenced to hang. And this shows where our criminal justice system is. This man was charged in 2010. Madam Speaker, we're in 2023, and there's now a conviction. This is the state of our criminal justice system. So when you talk about virtual courts and that the waterfront have courts and that you have buildings going up all over the place, Madam Speaker, this is the state of our criminal justice system. It is deplorable. We, on the opposition, we care about Trinidad and Tobago, and we want to help this government. We want to help Trinidad and Tobago fix the system. Madam Speaker, I was part of that system when I served in another place. I appreciate what happens. My friend from Port of Spain South knows the issues that is taking place in the criminal justice system. They come and tell us that this is the greatest bill, this might be the panacea, this is the silver bullet. Madam Speaker, we reject that submission. Because when you have prosecutors operating in an environment where they have no space to work, where there is a large number of vacancies. Look, I have an article in my hand here, dated the 2nd of May 2023. DPP's office short-staffed by 114 employees. 114 employees. And when the Attorney General piloted this bill, he gave us statistics that there are about 38,000 outstanding indictable matters in the criminal justice system. Then San Fernando West tells us there are 18 masters. How can 18 masters deal with a backlog of 40,000 matters when an additional 8,000 joins the system and you have 140 prosecutors vacant at the office of the DPP? Madam Speaker, that is a snapshot of our criminal justice system. And then you tell us that this bill is going to help? You tell us that this bill is going to help. Madam Speaker, the bill may work if you give resources to the system. But you know what that takes? That doesn't take this parliament. That takes the willpower of the executive to allocate resources and properly manage the system. But Madam Speaker, by no feat I am saying that we are on this side agreeable to some of the provisions in this bill. There are some very serious provisions in this bill that I wish to highlight, Madam Speaker, that will take us into some very, very concerning and trying issues. Now, let me just explain to the general public what we're trying to do here today, because I think we as MPs in this House owe it to the general public to make them understand what process is being taken place in this House. In the criminal justice system, as it currently stands, all matters will be initiated from the magistrate's court. There are two separate types of offenses. There are summary offenses and there are indictable offenses. A summary offense starts and finishes at the magistrate's court. An indictable offense starts in the magistrate's court, but it finishes in the assizes in the High Court. And what this process we're trying to do here today is specifically deal with indictable offenses only. We're not dealing with the summary offenses. So the system that currently happens now, or that is enforced now, is that when a police officer lays something called an information in the magistrate's court, that will now generate a charge on the accused person. The accused person will be brought to court, but he will not be called upon to plead because it's an inquiring magistrate. That magistrate does not find guilt. All the magistrate has to do is make out a prima facie case on whether or not there's sufficient evidence for this person to be tried in the High Court. What the bill is trying to do, in its essence, in a global sense, is to bypass that entire process of a magistrate sitting as an inquiring magistrate, because what happens is basically a trial. When the police officers or the prosecutor brings witnesses for the court, the defense is allowed to cross-examine those witnesses. They're allowed to make submissions. They can make no-case submissions. And that takes years, Madam Speaker. Sometimes we have preliminary inquiries going on in this country for many, many years. Sometimes I believe up to 10 to 12 years we may have a preliminary inquiry going on. And that is something that we saw as a government in 2011 that needs to be addressed. So therefore, this bill was birthed in 2011. And when this bill was birthed in 2011, the idea behind it was, if we're going to bypass the preliminary inquiry stage, because as San Fernando West rightly pointed out, there is judicial pronouncement on whether or not you could abolish preliminary inquiries, and that is coming from the case of Hilroy Humphreys. And when that process has been abolished in terms of the preliminary inquiry, getting rid of the cross-examination, the lengthy submissions, you now have an area called the Master's Court, where documents, witness statements, exhibits have to be filed. There's no right of cross-examination for those witnesses. All that happens is that the lawyers representing the defendant or the prosecutor will now make submissions on that evidence that is presented by the prosecutor. That is all that they have to do. And that is what this bill is trying to achieve. But we have some amendments here, Madam Speaker, that may cause that system to collapse. As good as an intention as it may be, I am saying that we have to pay particular attention to some of the provisions. Because we in this Parliament took an oath that we must uphold the law and the Constitution. We must pass good law. We must pass constitutional law. We must pass law that is bulletproof. And as an opposition, we have a constitutional role to ensure that we pass those good laws. And Madam Speaker, I want to address you on 4 very important points when it comes to this bill. The first point is that there is some vagueness of the provisions of the law in relation to the powers of a magistrate. On the second point I want to address you on, Madam Speaker, is that there's a circumvention of the protections under the Interception of Communications Act to access data from individuals. Our third point is that there's an erosion of powers of the DPP. And on the fourth point, there's an issue with respect to anonymous witness evidence. So, Madam Speaker, let me begin by addressing you on the first issue that I raised in terms of the vagueness of provisions of the law in relation to the powers of magistrates. And I want to take you, Madam Speaker, and please forgive me, I have a consolidated version of the bill. I may not be able to refer to the specific clause, but I could tell you which clause which section of the Act is being amended by the clause. And Madam Speaker, when you look at the amendment that is being made to Section 4 of the Act, it now allows for an inclusion of a 4 subsection 2, which says basically, and this is the application section of the Act, where a magistrate shall determine whether the case is to be determined in accordance with this Act, A, after giving the prosecutor and the accused an opportunity to be heard in this regard, and B, in the interest of justice and fairness to the parties. So what does that mean? It means that if there are proceedings in the magistrate's court that had begun before this Act came into force, the magistrate now has to make a decision whether this new piece of law will apply to that previous case that was filed. But there are 2 thresholds that the magistrate has to consider. One being that you must give an opportunity for the prosecutor and the defense to be heard, and 2, it must be done in the interest of justice and fairness to the parties. Now, Madam Speaker, what does this mean? And I raise this in the context of a magistrate is a creature of statute. A magistrate is bound by the 4 corners of the law. They can't go outside of that. In fact, a magistrate has no inherent jurisdiction like a high court judge. A puisne judge sitting in the high court has an inherent jurisdiction to use wide discretion to determine whether or not they can exercise their inherent jurisdiction in the interest of justice. And if you allow me to give one small example, if we look at the civil arena, a civil judge, even when making a decision on some applications, let's just say, for example, a relief from sanctions application, they have to consider something called the interest of justice. But how do they understand what does that mean? They go back to the overriding objective of the CPR, which is to deal with cases justly, deal with it expeditiously, manage the resources of the parties. When you look at Section 4 here, there are no factors in which a magistrate considers to determine what is the interest of justice or fairness. And that is very unfair to one, the prosecutor, the defense, and even the court. Because if the court is bound by these 4 walls of the statute, there are no inherent jurisdiction and they are creatures of statute, we must prescribe a little more in detail what this magistrate has to consider. Because if this magistrate goes outside of his jurisdiction, well, that is a challenge for an entire criminal matter which can fall apart based on a technicality of the law. And that is something that this Parliament ought to prevent. It ought to prevent. And I can quote a case, Madam Speaker, all the way from 1875, Johnson, that says, this is a Queen's Bench, 10 Queen's Bench 544, that a magistrate jurisdiction must be conferred by statute and their powers are derived from the enabling act. Clear, 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 Madam Speaker. And that is a point that we have to ensure that we don't allow a magistrate or a court to go outside or step outside of their boundary. Then, Madam Speaker, I want to look at what we have seen in this particular provision that deals with the circumvention of protections under the Interception of Communications Act. And I would spend a little more time on this particular area, Madam Speaker. And this is an amendment to Section 5 of the law, and it deals with an insertion of 5A, 5 capital A, subsection 1. And you would allow me to read, Madam Speaker, what it says. It says, where a search warrant has been issued under this Act for the purposes of obtaining communications data, stored communication or stored data, sections 12, sections 13, subsection 2 to subsection 4, and section 14 of the Interception of Communication Act applies. And 1A, subsection 1 applies to a search warrant issued by a master under this Act or to a search warrant issued by a person referred to in section 10 who exercises concurrent jurisdiction with a master. Very technical terms. What does all of that mean? It means A master now has the ability to issue a search warrant to get specified data that is defined under the Interception of Communications Act. So we're dealing with communications data, stored data, and stored communication. Simple. If you look at the definition that was made in the amendment to the Interception Act, these are things like text messages on someone's phone, photographs on someone's phone. It deals with their call logs, their message logs. These are all of the stored data and stored communication that will be in someone's phone. And what the law now allows is for a master of the High Court, not a puisne judge, a master to now have jurisdiction under the Interception of Communications Act. And the master, in issuing this particular search warrant, uses the standard reasonable grounds for suspecting. Now, that is a very, very low standard in order to obtain a warrant. You normally have a standard of a reasonable grounds for believing an offense. Those two are two different standards. A reasonable grounds for believing an offense has occurred. This is saying a reasonable grounds for suspecting an offense has occurred or will occur. And Madam Speaker, when you look, because we have to read this particular provision, because it refers to Section 13 and 14 of the Interception Act, in line with the Interception of Communications Act. Under that act, in this particular provision, who can get this warrant? A constable. A police constable can go before the master. A police constable can go before the master, makes an application that they want a warrant for stored data, stored communication. And all the master has to say, well, I reasonably suspect that this offense is taking place and they will have information. Let me issue this warrant. But Madam Speaker, when you look at the protections under the Interception Act, there are 3 authorized officers who can get that information. And these are the authorized officers: the Commissioner of Police, the Chief of Defense Staff, and the Director of the SSA. Now, this act that we are amending is allowing a police constable to go before a master and get that. And before the Commissioner of Police can even get a warrant under the Interception of Communications Act, they have one heavy threshold to cross. They must show that they have exhausted all efforts before they can go to intercept communication. They have to go before a High Court judge before they could get this information. Madam Speaker, the threshold is very high. There are so many protections because it's an invasive tool in terms of rights to privacy that there are so many protections inbuilt in the parent act of the Interception of Communications Act. And what is very surprising is that while this standard is now so low and a police constable going to get this information, they did not allow the government, that is, for these protections to apply to this search warrant under this act. It did not apply, Madam Speaker, and that is a very dangerous piece of law that we're dealing with here, because it deals with persons, with a police constable going and getting this information. And when you look and you read this provision with what is already existing in the law, do you know that this information can be disclosable to a minister? What? What? If there's a mutual agreement between this country and another country for exchange of information, the minister can access the stored data that the constable get through a search warrant. And Madam Speaker, we are saying that this threshold for getting the search warrant is absolutely too low. It is too low. And they can quote Surat, they can quote Suraj. This law is disproportionate, Madam Speaker. Oh yes. It is disproportionate. Agreed. It is totally disproportionate, Madam Speaker. And Madam Speaker, under the law, we just spoke of judges being able to issue warrants under the Parent Act. We spoke about the amendment being made here. The master is allowed to issue the warrant. But then it goes on, Madam Speaker. When you read on to the bill, it says a master under this act. It says a search warrant issued by a master under this act or to a search warrant issued by a person referred to in Section 10 who exercises concurrent jurisdiction with a master. Do you know who exercises the concurrent jurisdiction with a master? It is a registrar. So they're saying that a registrar can also issue the search warrant for stored data, stored communication, and communication data, Madam Speaker. Madam Speaker, when you look at that, you would see that this entire thing, it has to be, I don't understand who drafted this, because when you look at Section 10 of the bill, it says, for the purposes of this act, the registrar shall, subject to subsections 2 and 3, have and exercise concurrent jurisdictions with the master to issue search warrants. So a registrar is allowed to issue search warrants with concurrent jurisdiction of a master with no protections, absolutely. Madam Speaker, they are just coming with reasonable grounds to suspect. They are coming with reasonable grounds to suspect, Madam Speaker, to get a warrant. Look. So I don't understand, Madam Speaker, I don't understand how this government had read this bill together with the Constitution, you know. Because this can't be the Constitution of Trinidad and Tobago that they measure this bill with. Because this bill is converting Trinidad and Tobago into a clear dictatorship. Madam Speaker. Madam Speaker, I want to move on to my other point, which deals with an absolute erosion and dilution of the powers of the DPP under Section 90 of the Constitution. And I want to premise my contribution by reading into the record what Section 90 says, because it seems as though the Attorney General might be a stranger to this Constitution.
Oh, that's a good one. We believe that.
And Section 90 of the Constitution says, Madam Speaker, and I think I'm going to read it very slowly for the Attorney General. 90 subsection 3. The Director of Public Prosecutions shall have power in any case in which he considers it proper to do so. A, to institute and undertake criminal proceedings against any person before any court in respect of any offense against the law of Trinidad and Tobago. B, to take over and continue any such criminal proceedings that may have been instituted by any person or authority. And C, to discontinue at any stage before judgment is delivered any such criminal proceedings instituted or undertaken by himself or any other person or authority. Very, very far-reaching powers that the DPP has that was conferred to him by the supreme law of the land. Supreme law of the land. This government wants to come with a bill now, Madam Speaker, to erode the powers. And I read that Section 90 to make an analogy and the context of what currently takes place. After preliminary inquiries completed, the deposition, those are the matters that were heard in the magistrate's court. All the exhibits will be transferred to the office of the DPP. When I was there, they would have passed several files to us, and we do a summary of the evidence. And then we do a draft indictment. And once the DPP is satisfied, he will sign off the draft indictment and file it in the High Court. That is the procedure that currently happens right now. And what the DPP has is far-reaching powers. First, the DPP can lay something called a voluntary bill of indictment. That means he can indict anyone even without a preliminary inquiry. Two, the DPP also has, even if a person is discharged after the preliminary inquiry, he can obtain a warrant of committal, and then he can determine the case based on the ruling of a judge whether to indict someone. And the last position is that on the deposition, if a person is charged for one offense, but the DPP reviews the deposition and he finds that there are any other offenses the person can be charged for, he has the power to also indict for those additional offenses. And the indictment only comes after the preliminary inquiry. Madam Speaker, I heard an argument from San Fernando West saying that basically there will be a triggering of the process now with an indictment. The process as currently stands is that the information that is laid will go on to the PI, go on to the hearing, whether to discharge, sufficient case made out, and then the indictment is laid. But in this case, the Attorney General, during his piloting of this bill also, he would have indicated, Madam Speaker, that when you look at clause 19 of the bill, he said, and I'm going to quote the Attorney General from his Hansard on the 5th of June 2023. He said, as mentioned earlier, the bill proposes the accused will be subject to a sufficiency hearing in those circumstances, with the rationale being to balance to ensure that while Section 90 powers of the DPP are maintained, sufficiency of evidence is to be judicially assessed. So what this government is now trying to introduce here, Madam Speaker, is that if the DPP lays a voluntary bill of indictment, he is now subject to a sufficiency hearing. So that is an erosion of the power of the DPP according to Section 90 of the Constitution, because if an indictment initiates a proceeding, why should the DPP now be subject to a sufficiency hearing? Why are you going to make the DPP do that? Now, I heard the Attorney General also said that there have been consultation. I don't know if there's consultation on this bill, but if there's consultation on this bill, I would like the Attorney General to disclose the comments and the position of the Director of Public Prosecutions on this matter. Because I don't know if the Director of Public Prosecutions agrees with this particular law that erodes and dilutes his power under this bill. And I can't understand why the Attorney General can't make full disclosure of the comments of the DPP if there was a consultation, if any, on this particular piece of legislation, if any, Madam Speaker. Madam Speaker, when you look again at how this entire process is going to take place, it seems as though it is very confusing. Because under Section 6, which is being amended under the law, it says that the process can be triggered by, one, a complaint. Now, I have no issue with that. If the complaint starts the procedure, then the police will have to lay their witness statements, bring their exhibits before the court. But then you're saying that it can also be triggered by an indictment. And then you're saying that in the same breath, that the Criminal Procedure Act will apply to indictments. Madam Speaker, the Criminal Procedure Act provides that when an indictment is laid, it initiates the High Court proceedings. It doesn't initiate sufficiency hearings that is prescribed under this law. So this piece of law is in direct conflict. It collides, actually, with the Criminal Procedure Act that is part of our law that we are not amending here today, Madam Speaker. And that is some of the issues that I have with this bill in terms of the clarity in which this is drafted. Because you can't have two systems now, one via complaint, one via indictment, and we don't understand really what is taking place. And then, if the DPP has the power to prefer an indictment, there are provisions in this bill that now allows a master of the court to amend that indictment. The master is going to amend the indictment. If the issue that the government is trying to fix, if the mischief is that the DPP's office is taking way too long to file indictments, there's one simple fix, Madam Speaker: staff the DPP's office. Staff it. That office has been suffering, Madam Speaker. Madam Speaker, as a former prosecutor there has been word, there has been rumors going around that they have been begging and pleading for better terms and conditions. Why doesn't the government take an initiative to make the packages a bit more attractive so that lawyers will want to go and work in that office, Madam Speaker, and not leave? There's an exodus from that office because persons tend, and nothing is wrong with that, because persons from the DPP office may have a desire to sit on the bench, and nothing is wrong with that. But where is the succession planning that goes on at that office? And if that is the issue, provide the resources. Don't come with a shortcut piece of bill here to circumvent constitutional protections to try to fix a problem. To try to fix a problem. Madam Speaker, you see, there are a lot of inconsistencies with this particular law, and I want to go back to that issue that deals with the voluntary bill of indictment. Because when you look particularly at Section 6 of what is being amended, there's a new provision that is being included here, in that where an indictment is preferred and filed under subsection 2, without making a complaint, a master shall issue a warrant of apprehension of the accused to compel the appearance of the accused before the purposes of an initial hearing. So what they're saying here, Madam Speaker, is this: is that there are twofold tests that is going to take place here. Once the complaint is made, person is brought before the court, the first hearing, or when the DPP prefers an indictment now that they are trying to prescribe, is that they will have an initial hearing. And in that initial hearing, it will be as though it's a case management conference. It will give deadlines. It will give timelines on how the matter is to progress. It will have something called a scheduling order, giving the accused an opportunity to seek legal representation, go towards a legal aid to seek legal representation. And once this initial hearing is done, they will then move to a sufficiency hearing. And Madam Speaker, I could just point out one area of bad drafting in this law, Just one area, I could just do that very quickly.
Honourable Member,
Yes, please.
you have just a few more seconds left. It is now 4:30. I think now is a convenient time that we take the suspension, and we will resume at 5 p.m.
Sure.
Okay, so this House is now suspended. We'll resume at 5 p.m.